All right, so we're on the record in 26-01195. That is People of State of Michigan versus Antonio Lara. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Ms. Rothstein.
Good morning, Your Honor. Vita Rothstein on behalf of Mr. Lara, who is present in the courtroom and seated to my right.
And sir, you are Antonio Lara, is that correct?
Sir.
All right, thank you. This is time set for a preliminary examination today. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both parties will be unconditionally waiving their right to hold a preliminary examination in this matter. We'd ask the case bound over and the charges in the complaint. Initially, Your Honor, the offer in this case is to do continued negotiations up in circuit court for a global resolution. Mr. Lara has another pending matter up in front of Judge Stokes.
And is that a fair statement, Ms. Rothstein?
It is, Your Honor.
All right. May I inquire Mr. Lara of his waiver of the preliminary examination?
Yes.
Mr. Lara, you understand that you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You're represented today by attorney, what's your first name? Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to preliminary examination. The offer, which is negotiations are going to continue on this case with, I think it's a separate file, a pending file. That is the offer at this time. Is it your wish today to waive your right to a preliminary examination based on negotiations are going to continue? Is it your wish today to waive your right to a preliminary examination based on negotiations are going to continue between your attorney and Ms. Maycomer concerning both files? Okay. Ms. Maycomer, do people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for the party's signature. All right, Sean, so if you provide that to the attorneys and then.
If you can.
Thank you, Sean. All right, I'm in possession of the bind over documentation on 26-01195. It has been signed by all the parties. We're going to indicate that the examination was waived on today's date, which is May 28, 2026. Bond is set at 2,010%. Anything else for the record before I sign the bind over documentation? Ms. Maycomer.
No, Your Honor. Thank you.
Ms. Rothstein.
No, Your Honor. Thank you.
All right. I'm going to sign the bind over documentation. So, Mr. Lara, your time in district court is done. You're off to circuit court, where you get your next date of appearance from your attorney, Ms. Rothstein, okay?
Sir.
All right. You should be all set, sir. Thank you for your appearance today. And what case did you want to call next, Ms. Maycomer? My understanding is Ms. Wanji is in front of Ms. Judge Stokes.
She is, Your Honor. I can go find Miss Fortuna Gill. She's handling the other 8:30.
On Withers and Glenn?
Yes.
All right.
She'll know better about.
All right, what case did you want to call next, Ms. Fortuna Gill?
Did this waiver go on already?
Yeah, we already got done with Mr. Lara.
We should be ready on Marquise Glen.
All right.
Oh, we need to sign the paperwork, you're right. So we could go on Charles Withers.
All right.
Thank you. I appreciate your help this morning.
All right.
Hi, Josh.
Bye, Ms. McComber. So we're on the record in 2601-207. That is People of the State of Michigan versus Charles Withers. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
Vita Rossi on behalf of Mr. Withers, who is present in the courtroom and seated to my right.
And sir, you are Charles Withers, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people are unable to proceed towards the preliminary examination this morning. I do not have any witnesses present, nor do I have a good explanation as to why they wouldn't be present today. They were subpoenaed. All of my witnesses on this case are law enforcement.
All right. So,
I do anticipate a motion from defense counsel.
thank you. Ms. Rothstein.
Yes, thank you, Your Honor. So we would ask that the case against Mr. Withers be dismissed at this time since the people are not able to proceed. Mr. Withers is here. He did want to exercise his right to run his preliminary exam. He's ready to go. We're ready to go. So we would respectfully request that the case be dismissed.
All right. And so it's my understanding, based on the prosecutor's representations, that the people are unable to proceed. The complaining victims were subpoenaed. And obviously they've not been successful with getting them here today. So I'm going to have printed out at the defendant's request a motion to dismiss without prejudice. I might have to draft. Now I might have to draft you to get since Sean went to.
Thank you.
Sometimes it doesn't work. So you can give
May
it
I
to me.
approach?
Yes.
Okay.
Thank you.
Thank you.
All right, so I'm in possession of the acquittal or order of acquittal on 2601-207 based on the defendant's motion to dismiss without prejudice. The people are unable to proceed as indicated for the record, that the witnesses were subpoenaed. I will grant the motion to dismiss. This is dismissed without prejudice, which means that people could reissue if they choose to, but for our purposes today, the case is dismissed. And I do not have a GPS tether or a no contact. So Mr. Withers, you can decide if you want to keep this. It takes about 4 hours to purge from the court system, from the computer system. You can make up your mind. You have to, I think that's the court officer. But you should be all set. The case has been dismissed without prejudice. Anything else for the record? In 2601-207, Ms. Fortuna Gill.
Not for the people.
Ms. Rothstein.
No, Your Honor. Thank you.
All right, you're all set, Mr.
All right.
Withers. Thank you for your appearance.
Yeah.
Good luck, Mr. Withers.
So let us know when you're ready on Glenn. And then you can let us know on, because Ms. Wanji's got 2.
Yes, and I believe Mr. Doyle went to speak with his, I mean, that's not scheduled for another
That's
5
Barnes
minutes,
on 9:30.
but yes, he
Okay.
did, he has been here, and I believe he went to speak with his client.
All right.
Um,
Right, just let me know.
yeah, other than that, I believe we're a bit at a standstill.
Yeah. All right. So we'll adjourn for the next
All
until
right.
you come get me.
Thank you, Your Honor.
May be seated.
Yeah, no, keep in mind. And I just need to finish filling out what charges we discussed. Okay. The DWLs and non-registered vehicle. Does he have an advice for me, Lisa, sorry? Yes. There are 2 pages. 2. If you have, I'm not sure if you have to speak with my the claim.
I will, I spoke with her. and I will speak with her again this morning to see
Okay.
what's what.
Cool.
Melanie, they've been waiting for you.
Hi.
They're happy to see you.
How's it going?
I see you more than I saw you for
I know, I'm so
3
good to
years
see
on the
you.
road.
I know. I will be right back.
Okay, so what are you thinking? On Gomez, are you gonna ask for an adjournment?
Is a good idea.
We're gonna Uber him in, and we're gonna order the Uber in 5 minutes. That's why I'm asking.
Oh.
And I figured if you were gonna ask, we could probably go in chambers to figure out if I should order the Uber or not.
Okay.
But if you weren't gonna ask, I'll send him in.
Okay, let me talk to him.
Okay.
But you guys want to do the stuff no matter what.
Yeah, we want to preserve it.
Okay, that's okay. I'm gonna talk to him because I did this see. So you can get the alert info fast.
Mhm.
35 or 30.
Right, right.
If you don't find it, so I talked about in one of the first find it Friday, but I didn't.
Oh,
have
but
time
you
to-
did find it though
I did
eventually.
find
Okay,
it, but
good.
I didn't have time to.
Right,
'cause it was
understood.
spoiled. But I'm gonna go talk to him and show him some of the stuff.
Okay.
But no offer, nothing.
Yeah, we want to run it and see how testimony comes out.
Okay.
Um,
And you say, well, there was a chance, depending on the testimony. As to,
depending. I don't know. I really don't know,
Okay.
honestly. But that's part of the reason we want to run it. It's
Okay.
a little messy and we want to sort it out, make sure it's charged right.
um,
I do not anticipate having a victim here, but I do have an officer here for the PIP.
okay. Yeah, you told me that. You
And
were
so we
going
would
to-
dismiss everything else, but we would keep the PIP.
Okay. So,
Okay, so on that one, I'm waiting. I do not have a victim, so. Can't. Well, there's the Arnos. Let me see. Yeah, there's the Arnos. Let me go talk to my officers
okay.
and I'll leave, because there's the Arno causing injury. First, we'll probably want those upstairs. I bet we'd be willing to do just the Arno causing injury upstairs and drop the other two. But I need to confirm.
Okay.
Because there's not gonna be a victim here, so all the victim crimes would be dismissed, and then as far as the assault on the police officer, only the one causing injury, I would think is what we would be wanting up, and we could probably get the other two. Okay.
Alright. Sorry, I'm late, but
No, I get it. What are you gonna do? And
and I tried to change it.
yeah.
And, but I didn't want to dump that on one of the attorney. because
Okay,
it was
thank you.
already-
You're welcome.
My client is really
Okay, understood. Just let me know
Okay.
on Gomez because we're gonna order that Uber here in a few minutes.
okay.
We are fancy.
Oh, yeah. So, Mr. Quinn is ready whenever, but
Okay.
anything else going there? Do you want me to speak with Ms. McClendon?
Yeah, that would probably be helpful because I don't have anything else ready.
Okay, great.
Let me tell.
No, Daddy.
Red news. Red news. I'm looking for.
Yeah. And what case is that on?
It's for,
It's the same
Barnes
one.
and.
Oh, same case. Okay, yes, if we could chat out in the hall very briefly, that would be.
Okay, Mom.
Yeah, we're gonna go to the hall.
So this.
That boy. That boy doing the phone. What he's doing that phone?
I didn't have.
You know,
Oh, well, he's a witness unless he's.
that wasn't.
She just. told me that. I think for your son.
Right here, buddy.
Bye, Mom.
Bye, Mom.
That boy wants to subside you. Look at him, grown man, look at him.
Look, I'm not coming over there.
Yeah, right, let him sit there. He grown, that boy grown man.
Yeah.
Look at him. You know he grown, he got a cell phone.
Heck yeah.
Look at him.
Well, I didn't teach
He know
Coco.
right, he know what he doing. Look
You
at him.
like the Coco.
That boy.
It's kids his age are better at technology than me.
You sure?
Yeah, I'm terrible at it.
That's your son?
No, he's my neighbor's son.
No, he's my best friend's son.
Brother.
He got a girlfriend?
Right here.
Oh my God. This is girlfriend.
Look at me, Pop. Look at me. Yeah, he's calling you.
Look at your eyes, he look at him. Look at her.
They're best friends.
We like Coco.
Look at how she look at it like they baby. Look at so.
We wrecked it in it.
Oh my
We wrecked it.
These kids today, I'm telling you, they're crazy. They're a different breed.
They be dating at a young age. If my grandma knew I was dating back then, the whoop out you.
Oh, I know.
You allowing your rating? All right.
You hear my boy here. Might be hear my boy. Hey, you know what? I used to get whooped everything. Grandma don't play.
Nowadays.
Child abuse. Whoop a kid, man.
Your mom's
They don't be
here.
crying about it.
Bye.
They gotta call the police. See, he'll call the police if somebody hit him. He got a phone in his hand. That's what's more than.
Mm-hmm.
That's my mama.
Mr. Flynn and Ms.
This your mama's phone?
We doing?
Somebody's McClendon would be a waiver and Mr. Flynn would be.
That boy.
Find some paperwork already with Mr. Flynn.
That boy wants to sit by himself. He got somewhere to
This is
sit
my
by himself.
information and belief.
Okay,
It's not
we
here.
will go with that.
Kids so smart these days.
They're digital children. I'm telling you, they're from the digital age. They just know too much.
That boy, no, do that phone. Ain't that something? We ain't got no phone. We have house phone.
I didn't have a cell phone until I was married. Wrong.
I didn't get a cell phone until '96. I was 28 years old.
It was probably like after that I got mine. I think.
See, I'm 60 years old.
Are you? My birthday's Saturday. I'll be
That's
47.
your husband?
This is my fiance.
Right there?
Yeah.
I thought you were talking about
No, no, a little young.
him. When y'all gonna get married? When y'all gonna get married? You know,
We don't know. Well, we're supposed to get married on Halloween, but I think we are gonna have to push that back a minute.
why? You got no money?
Just a lot going on right now.
So what y'all in here for?
I don't know if I'm allowed to say.
Yeah.
But I'm an attorney, I'm a lawyer.
I would tell you what. I don't wanna get in
You
trouble.
know I already
Yeah,
know.
look at your face.
Look, I'm real smart. Y'all got into the neighbors. So your dog probably beat somebody.
Huh?
I see I'm smart. You y'all.
You could be right. Who knows?
Somebody. So y'all, when you say a witness, I'm smart. So somebody got to tell what happened. You got to listen, you gotta learn this.
And it's a while.
Look,
And we went
you
over.
can get a charge for that for real, for beating up somebody. I swear, here's somebody.
Daddy. Bye. No, me. Mira.
They can come up with all the teaching for this. The video with the rig in one hand and the belt in the other says it all. That's what I'm. I've seen it come back to the house. Just want to let you know. Thank you for that.
Absolutely. So you're welcome to stay around for that. You want, we also
If we leave.
Yeah, it just probably won't be till later this afternoon.
Okay.
So,
And is it gonna make any difference whether I'm here or not?
No.
The choice that you make?
No.
Okay. All right, well, I appreciate so much. Everything you've done
Absolutely.
for this.
and then, if for whatever reason, this looks not fine, please call me.
Okay.
But I will make a note of it. It shouldn't be an issue, but if it is, please. Please put me on it, okay?
Okay.
Oh, I can on the
You know, people should leave neighbors alone. If you go to my house, don't just go to my house, talk to them. You go jail. Look, so what you do, telling people stay away. Don't let nobody.
Sorry. They can go.
See,
Yeah.
neighbors don't get along because people jealous.
Right.
Don't put your neighbors.
I gotta grab this from her.
The neighbors are working anyway. People get killed because people on somebody's yard. This man cut on the neighbor's yard, he got shot in the head.
That's crazy.
Shot him in the head, killed him.
That's crazy. I don't understand. that. I don't
See,
understand.
And when somebody call the police, somebody goes to jail. Ain't nobody, that's sad, people got to get along.
I know, we're supposed to love each other.
It's kids that do stuff like that.
Well, but the kids are getting it from somewhere.
No kids ain't.
They
They are.
Kids like to cause
Yes,
problems.
thank
Look,
you.
kids
You
like to cause
do.
problems.
Nice
Look,
meeting you.
kids need to stay in kids place and leave people, grown people stuff alone.
That's
That's how you
true.
get in
I will
trouble.
agree with that. I wish you the
A
best
kid,
of luck.
the fact they grown at 13, they get knocked down. I swear, hey, they'll get knocked down. Hey,
You should be ready to move some stuff.
what's wrong? You okay? What about the man today? So you got a charge?
Sir, could you please not speak to
Yeah, what
them?
about a
Thank
man?
you. Could
I
you
ain't
please
mad.
not speak to them?
Damn, everybody like this in the world. You just got a charge. You know, well, I mean, Miss Miracle, you be all right. They might
So,
be dropping
I thought there
charge.
was another page, but, I mean, we may have lost it. I thought there was another page on the
Hey, you go to jail? Come to jail.
Oh,
Just be a
I'm
woman.
not as
Yeah.
familiar with the Donald
You might
Trump
have
report. I
been-
know there's.
Oh, and I
paperwork.
also,
You
you guys
just
just need to file.
Just don't commit no crime.
There's advice for it as well.
To leave people alone.
Oh,
I'm
another
concerned.
one.
Call me. I know.
I can have him sign another.
I like
Yeah,
your mama,
it's
she's
problem.
pretty. Hey,
I
mama.
don't, that one popped up.
Ooh, mama pretty.
All right.
Ooh, I love you.
And we don't need
I'm a
the order
man.
for a DNA sample. Because I thought there was a portion where I could
Hey,
say there was a
you know my
sentencing
name?
agreement.
I'm the lady.
That's a write-up.
Be quiet. Be quiet.
Thank you. Appreciate that.
I'm over.
Henderson is grayed
I'm
out.
small. I might get y'all a big job.
Henderson? Yeah. 'Cause it's
I
not
go
on
right
the
there.
docket, but then when I went to. Don't have Henderson on the docket.
Okay,
Yeah, I don't
bye.
either.
I'm
It's
trying to
grayed
help
out,
people.
like,
I'm a attorney.
they got it and right here.
Look,
This was officer, but it's grayed out.
You got no client. They don't want to
So
talk.
should I
They want me to
tell
help.
both of them that
See, y'all might
it
go
is
left
not
and
on our
right.
docket? Yeah.
Go to
Okay.
jail. And you
I have
never
no
do it
idea.
again. And right man, how you doing? You my boo? You my boo? I thought was North and Grady. Why y'all laughing?
How are we looking, Miss Haley?
We're ready.
Ready?
Rusting.
What now? Who first?
Yeah. I don't think it's gonna be successful, but you are welcome to sugarcoat my losses.
I'm tired of coming to court. Don't stop too many crimes.
Have fun.
We got black people, you gotta stop too many crimes, man.
Okay,
gotta do
Glenn,
better
that's
than
a
this.
felony plea. And I'm gonna embarrass myself, 'cause I don't know what I'm doing, so I filled out this paperwork. And I think we may have lost a page. I know, I know.
What's
right here?
Look at me. Hey, you know
This,
you like
yeah,
Ray
this is a
Lewis.
DNA sample. I was told we don't need this.
I ain't no Ray Lewis, your dad.
Oh, and
You just like Ray Lewis.
I don't know.
I don't know
I
either.
I think you should
You
probably
talking-
still have it filled out.
Look, you
I think it's filled out.
know I'm talking to you.
Yeah, it's just
You
Judge's
just like
signature.
Ray Lewis.
I
He
think
can
it's
fill
filled
that out
right
if he
there.
wants.
and
And
it's
then,
HYTA.
yeah, because there's nowhere for me to
That's
write that
Beyonce's
it's
daughter right there.
HYTA.
Oh.
But I thought there was. That's what I'm saying. I know. Don't yell at me.
Let me put up another one.
And we'll
That's
match
Ray
it.
Lewis.
I know.
Well, fill in the
Ray
blank.
Lewis. That's little baby right there. Little baby.
There is a number there. I
Hey,
just can't read it.
Oh.
There you
Okay,
go.
thank you.
Okay. Let's see. Okay, so the officers are gone. We sent them
how you
home.
know? At least say, I already said.
So we're waiting on Jones, Johnson.
I'm out there to see who we're talking. I'm nosy.
Yeah,
I was-
I got you. I mean, I don't-
I'm a nosy. What do you mean? I'm happy.
Oh my goodness.
Oh.
What? Oh. Only get there and shake it. I can't wait to get outside. I'm gonna dance on every tree out there. Every tree I find. I'm already high. I'm high as a kite. I suppose, what do we use? That cognac. And that moonshine. I'm gonna be silly. Dog can't do that. Dog is better. What about laughing?
Yes. Okay.
I'm burning back.
Won't happen.
Key, look. Don't. Give me some milk and cookies. Talk to the hand. Talk to the hand. What about that? You got my money? I'm a,
Well,
Yeah, this was the first.
I make a lot of money.
So he was, but that's what I'm trying to figure out, is our officer was also subpoenaed, and then if someone at the court was like, I'm assuming because he had a break.
They late. Mine was at 9:30.
and that was probably needed, because he said, well, he hasn't.
Right.
Right.
So,
Right, it was canceled.
yeah.
I swear.
so
They was
she's
I
in our
got my
office
charge.
in this case.
Every time I come to court, they got my charge while I go to court. Because I'm a good person.
So what do you?
Everybody in the whole entire land. No.
All right, it all makes sense. I'll send her off.
Okay.
Lands in
Thank you.
Oakland was everywhere, all over the United States. How you doing? I like that bag you got on. You used to be a cop in the street.
I got it in a box of Cracker Jacks.
Oh, Cracker Jack. He said I got a bag of Cracker Jack, mom. That what you said?
Nobody else will.
Cracker Jack. They don't make Cracker Jack no more. Oh, they got Jack in the
He's not
box.
graduating. He's not old enough because I remember when he was born. That would make me older and I'm not that older, much older. And I
You look young, man. You look 20 years old.
I'm telling you right now. he's
Man.
not- So he is what, still awesome.
Hey. My light came on. You wear your phone. The light come on. See it, man.
What's he gonna do?
We put the elbow on. Watch it. Watch it.
Doing what?
Like clap. Elephant. What the elephant? Yeah. Hey, what the elephant? I hear an elephant.
Never be alone. So that, not anymore. No, it's been 2019 since I was here.
I'm gonna be right back.
Hey, what the elephant at? There's the elephant here. Man, somebody, you heard the elephant.
Hang on, got it.
Hey, look, give your phone like that. You know how I do it? You never know how you do that. Clap your hand in the phone, clap the elbow. You never seen that before. Have you seen that? You see it now? Oh. You in trouble, are you?
Where's all the people from jail?
Jail.
Are they here yet?
Who? Jail.
Yeah, are they gonna be coming in here?
Who?
Anybody from jail, the judge gonna see them? Anybody, you guys know? Let me talk to these official people over here.
My God.
Pardon me. When do they bring the defendants from the jail?
I have no idea.
They
I don't
gone.
work for the prosecutor.
Everybody going back to jail. They gone.
You're an attorney?
Yes.
Okay, I don't know how to ask this.
Oh, God.
I don't
Step
know
all over
your
y'all.
name, but
I'm not, if I did, I wouldn't speak to you about it.
not even a yes or no?
I said I'm not.
Okay.
Did leave with that.
Yes, you did. Thank you so much.
You're welcome.
You know, mine that in jail got caught.
Yeah, he's got today. Excuse me, sir.
What's his name? Your son?
No. what time do the defendants from the jail usually?
Are you talking about Mr. Gomez?
Yes, sir.
Whenever the attorneys say they're ready, have them brought up.
And, okay, from what I understand, he was supposed to be seen around 10 o'clock.
That's correct. His hearing is set for 10 o'clock, but I'm not sure it's gonna go off exactly at 10 o'clock, depending what the attorneys are discussing.
Okay, my thing is, I put in my card to pay for my parking and they only let me pay up to $9.59. So I want to go add minutes to it,
Go,
but I don't know
go
how.
plug the meter and come back.
I don't know how to add minutes to what
I don't know either.
Okay, I just thought.
Yeah,
I'd
I mean,
see if I
usually,
could.
are you at a cell phone or a coin meter?
One of those coin meters that takes cards.
Do you have a debit card or something?
Of course.
You probably want to put the debit card in. so
Well,
you
yeah,
can
I
get the time.
tried all that, but anyway,
I
so
mean,
thank
if
you very
you
much.
want to go down and plug it, you're more than welcome to.
I got a quick question, another one for you, if you don't mind, because I don't usually come to these places here, but I would like to speak to the defendant's lawyer.
That's up to the defendant's lawyer,
Right, well,
not up to me or the
how could
prosecutor.
I find her?
She should be here. Miss Wanji, I believe.
Yeah,
She is here working on other cases right now.
okay, so, man, I need to speak to somebody, kind of private. You got a second?
No, I do not have
You
a
don't?
second.
Okay. All right, thanks.
Yeah, she's a black female. She's an older lady. She's been working in the courtroom this morning. I'll
Okay.
point her out to you when she comes in.
Okay, thanks. I'm gonna go take care of my
Yeah.
parking problem.
Definitely go take care of that.
Thank you, sir. I appreciate you.
You're welcome.
Should be ready to rock and roll. Did Marcy come back with another packet? No. Okay. Nothing. I'm aware of. Sure. She did come back in and out. Yeah. Okay.
First time I was recording, I was scared.
Hi.
So now it is nothing now. The first time you go, you're scared. Yeah, you don't know, like, you time, I didn't miss it. You don't know. It's judge decision, prosecute. They got a lot of charges. You go back to prison. If you get in charge, you put them together. They fuck. Like you. So I'm trying to get no charge, no new charge. If you got any old charge, then we gonna do. Fight. Cause you violate. Hey. They'll violate your own probation. It's the worst thing you do. Go right back, do the whole 10 years. You cut your tongue off. You know what you get? Look at Ray Lee. He's like Ray Lee. He's a dog in Ray Lee. You dog. You play football? What's the problem? You can be running back. No, line back. You run over somebody. You better not get in your way. You big boy really on the road. No, Mexican on the road. You'll knock him out. He's not me. She gonna come with left and right. Look at myself. Man, I should- you gotta get my ass down. I know you like to fight. You like to fight. Look at them hands, right? Them big hands. You got the boxes up. Yeah, you look, put them up like that, man. Look, they fight. They don't do no more. Ratchets, pull their hair out. They come to a fist. My girl been balling the fist up. I started running. I go, "Ooh." Wow, she really don't do stuff with me. He wouldn't fight like a man. They ain't scratching his feet, bro. They come with a gun or something. Yeah. But you get your eye, both your face.
Do we have a different date or like should we just wait for another date here?
I thought that no one was gonna do TV. Please.
Okay, great, thank you, Your Honor.
I'm respect.
He attacked us. I'm like, who are you? I thought that was. I was like, I'm done. It's a big deal. Yeah, the police officer, so I stood.
So he was gonna knock you off the freeway.
The prosecutor said he has something like that. He's trying to get people to talk about stuff as well. And he's like, no, you're not. Just don't, not go, do it. Don't post stuff on social media either, just don't. Just general info.
When I pray, when I pray, no more singing.
Oh, boy.
They ain't got nothing. They ain't get no plug, nowhere. A plug, electric plug. Why? 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 I didn't see no. Where? Somebody whoop his ass. Don't damn man. What they waiting on? Ma'am, you a person?
Yes, I actually am.
What about me?
You're not,
I am.
are not. Calling that.
I'm a professor.
Yes.
I'm not the nerd, the dancing professor. You want to dance? How you dance? I'm down top the table, man. You gotta get up there.
That's pretty funny.
Why everybody laughing? What's wrong, baby? You happy? Baby, you can't. Your hair on fire. Look at your hair on fire. That's your baby or your sister? That's your. You all right? Amen. You use car?
No.
You ain't no car?
No.
Them girls won't like you. They won't like you. See,
You in here stirring up trouble.
how you know I'm stirring?
Yeah, I can tell.
I ain't stirring up nothing. I'm stirring up blizzard. I can be blizzard. You know what I mean? You know what I'm gonna do? I'm gonna dunk you. He don't. You know what dog is?
I do, they in the Bible.
An ass. Don't you?
They in the Bible.
Donkey's an ass. Yeah, ride ass, say gas. You gotta roll ass, you go. No, make your ass look like a black ass and a white ass. You want a big white ass too. And white hair, it's like a moon. Hey man, I'm gonna dreads off your hair. Hey man, I do dreads. They call me dread. That little baby right there. The most is scared. The most is scared. What little baby said? Pure cocaine. Big cocaine. My thing. Pure cocaine. What is pure cocaine? What is pure cocaine? Pure cocaine. So who's Machiavelli? Hey, sir. Who is Machiavelli? He got a long nose. It's all about my long. He gets
Yeah, I think you're right.
You do that.
Why did you know?
No tea. What is she? What is she? Oh my.
Maybe I'll send you an
You
But by all. She said,
Oh.
well, so now.
Oh.
She said after 100 some kind of way. Worst case, I was like, I didn't even, like when she said, I said, I didn't even say.
No, we have this here.
Okay, well, that's something. We are ready whenever you are, Judge.
What the rain mean?
Means you're gonna be raised.
So the charge will be dropped.
No.
Hey,
Good morning.
She said at least that's something.
Yeah, to
We were
appear.
gonna do it.
No, that's not what I meant.
When?
I just mean I have a example thing.
I didn't feel to appear.
Alright.
No. When I feel to appear on
That's what
them.
it is. On
When was that?
Timco.
Yeah. What do you think, Kenny?
There's a bill, I'm here now.
Do you have it?
I understand that you're here now.
Yes.
What do you
Yes,
mean?
your offer. I mean,
The judge will explain it to you.
How you
Just
bill a
letting you
bill
know.
I'm here? What that woman talking about? Call.
where is
Hey.
DK?
So
You want
what
me to
about
check?
court they want?
Yeah, that'd be great.
What you talking about? Well, hey. You tell the bill, Mr. Man. I guess so.
Let's see.
What you supposed, something else, man. Oh,
What misdemeanor would you like, Miss Patrick?
I get to choose.
Pretty much.
They won't told me, that court they
Do
on
you have
28, so
anything about this?
they told me I got.
I have it.
bill,
Where
they-
the fan is?
I haven't heard her, but I will follow up.
Okay,
Can I
no.
get a copy of
They
the?
said I got.
He told me that he told you to give it to me.
I don't remember
He
that.
didn't, okay, will you ask him that? Cause he told me to talk to you about it.
I'm here. I'm a court there on 28. I can't get
Well,
paid.
he can't make a copy in jail.
Hey, you gotta explain.
I'll pay for a copy.
I'm not the guy.
I
So-
can
I'm
find
here.
it.
I'm not white Jew.
Pardon me?
You can FOIA.
I'm
Bring it
Flores.
down to.
See,
All rise.
he didn't.
Only to do a disorderly.
Hey, you can see this?
Okay.
Get him.
But he got a big ass arm.
All right, where's Miss
Wants to
Brodsky?
run it.
We should probably arraign Mr. Henderson.
What?
You can come up here.
Oh, I saw you want me to be first.
I'm just arraigning you today. This is your attorney. She's from the public defender. Your attorney was Jacob Sarks at the hearing.
Oh, so just arrange me, that's all.
Yeah, yeah. So we're on the record in docket 26-01282. That's People of the State of Michigan versus Reginald Henderson. Appearances for the record, Ms. Fortuna Gill,
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
Peter Rothstein from the Ingham County Public Defender's Office, appearing for Mr. Sars on behalf of Mr. Henderson, who is present in the courtroom and standing to my right.
And sir, you are Reginald Henderson, is that correct?
Yeah.
Okay, thank you. This is the time that's set. I'm going to arraign you on a bench warrant. You were previously a bench warranted for your failure to appear on May 21st, would have been last Thursday.
Oh, I was incarcerated. That's what it was.
Well, you weren't here, and that's where you needed to be. You needed to be here.
Yeah.
Mr. Sarts was here, waited for you. You didn't appear. So a bench warrant with a 48-hour hold was placed on you. You had 48 hours to come and contact Mr. Sarts. None of that happened. And so we're arraigning on the bench warrant, okay? So that's why the warrant was issued for your arrest for the fail to appear at probable cause conference.
So it's a warrant now?
No, there's no warrant. Well, there's a warrant now. There's been a warrant since the 48 hours. So I would say since probably
I didn't even know
Tuesday, maybe Tuesday, there's been a warrant. I set cash bond for your fail to appear because you did not appear at 500 cash surety, okay? So that's what it's set at, 500 cash surety. That's why a warrant was issued for your fail to appear.
Yeah.
You have I think you have the prelim dates. We've already set those prelim
I
dates.
think so.
So probable cause conference is set for June 12th, 2026 at
Yeah,
8:30.
yeah, that's what.
And preliminary examination set for June 18th,
Yeah, so.
2026. The bond remains at 500 cash surety.
Mhm.
And you can go with Jeff,
Yeah.
and you can go with with my court officer concerning the bond violation, which has all been set. There shouldn't be a bond for you, but we set it at 500 cash surety as bond.
Oh, so what I gotta do now? Huh? So when I get out?
You'll let you know, you've been given the dates for the PCC.
Oh,
I know you'll be brought over for June 1st because we have a pretrial on an assault and battery for you.
yeah.
So I would assume you're gonna attend that via Polycom or however. Yeah, they were gonna put you on Zoom.
Oh, really?
But they may bring you over, and they bring over, you'll be just like you are now, okay?
Oh, really?
Yeah, that'll be on June 1st, and then we've set the PCC for June 12th and the prelim for June 18th, and I think you have that paperwork, all right?
Yeah, you know what happened? Somebody stole my paper,
Well,
so I didn't know.
yeah, well, you've got a problem because we can't find you.
What, find me?
Yeah, we can't find you.
What do you mean?
At PCC, you failed to appear, and your attorney was here waiting. I think Mr. Sarts waited till
What day that was?
May 21st. Yeah,
When was May 21st?
that was your PCC.
That was Tuesday?
That was last Thursday.
So I was then.
Yeah, I don't know, but you weren't. You weren't.
Yeah, I swear, I was in jail.
Well,
But so what? That was that day.
we'll find out. You weren't in an Ingham County jail because you would have been brought over. You were not in the Ingham County jail because you would have been
No,
brought over.
I got out that day. Then I think
All right.
somebody stole my paperwork.
All right, you can go, and your bond is set at 500 cash. And then you can tell Mr. Sarts that we found his clients.
How about my bond is?
500 cash surety.
I'm gonna pay it today. It's on my card, money, so I'm gonna.
All right.
I'll get it.
What is Jeff's last name? I always forget Jeff's last name. What is Jeff's last name? All right.
Oh, I don't know.
I always forget his last name. All right. All right. Did you want to go on Mr. Glenn?
Oh, we can, Your Honor. I believe we are missing a page, and I must admit, I also believe it's my fault because I think I saw the page. So I'm either A, crazy and I never saw the page, or B, I somehow lost this page.
What page are we talking about?
Which page are
Yeah, it's page 2 of the plea agreement where there's a sentencing where you would, because right now I have nowhere to write the HIDA agreement.
Okay.
And so
So
this
there-
says page 1 of 2.
Yeah, there's there's a plea agreement on my desk, that might have both pages.
Other than that.
Do you have any, did you want to go on any of the
Yes,
others?
we can go on McClendon.
McClendon. All right. And then I'll give you a chance to talk about that one and set it. So let's go on McClendon. So this is Sharnina McClendon. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss Rothstein.
Peter Rothstein from the Ingham County Public Defender's Office on behalf of Ms. McClendon, who is present in the courtroom and seated to my right.
And ma'am, you are Sharnina McClendon, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, it's my understanding that the defendant wishes to waive the preliminary examination. The people would do the same. There's an offer to be placed on the record as well. The offer is to plead to counts 1 and 2. Count 3 would then be dismissed. Additionally, for the record, all of the subpoenaed witnesses were present this morning.
All right. And is that a fair statement, Ms. Rothstein?
It is, and also Ms. McClendon would like to ask for a bond modification as well.
All right.
I did let
So-
Ms.
So once we finish the waiver, before I sign it, we'll do a motion for bond modification.
Thank you.
All right, so this is an unconditional waiver. The offer's been placed on the record. May I inquire of your client of their waiver of the preliminary examination?
Yes, you may.
Oh, wait, Ms. McClendon, you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against us by the people of the state of Michigan. It's my understanding it is your wish to waive your right to preliminary examination, have this case continue in circuit court. The offer's been placed on the record, so this is all being recorded. The offer's open indefinitely or till the First Circuit Court pretrial.
Yes, Your Honor, to the First Circuit Court pretrial.
So whatever date that is, depending on who you get in circuit court, the offer's open in the First Circuit Court pretrial. Is it your wish today to waive your right to a preliminary examination today? Is that a yes, ma'am? All right, thank you. Ms. Fortuna Gil, do the people also waive their right to a preliminary examination today?
Yes, Your Honor.
Yeah, I find the preliminary examination be knowing, voluntarily, and accurately made, the waiver, and I'll provide the bind over documentation for the party's signature. Thank you, Sean. Thank you, Sean. So I'm in possession of the binder of documentation signed by all the parties on 26/01/298. I'll indicate that the examination was waived on today's date. That's May 28th, 2026. Bond is set at 3,000 PR bond, and it's my understanding, before I sign the bind over modification, the defendant would like to address bond. Is that correct, Ms. Rothstein?
Yes, Your Honor. So in this particular case, there is a no contact order that's in place. It involves some neighbors. We're not asking that the no contact order be lifted. However, there's also a 2,000 exclusion zone, which is preventing Ms. McClendon from returning to her home. And she would like to ask if the 2,000 exclusion zone be lifted so she can return to the home. She's willing to respect the no contact order, make sure she has no contact with her neighbors. She just would like to be able to sleep in her own bed. She also has a 7-year-old daughter who, and they've been displaced since this condition was put in place.
I do have the no contact order for the 3 individuals involved in the felonious assault. But I don't see here it is.
I did look it up online and
It's 2,000 feet.
Yeah.
Where they work, live, or go to school. Ms. Fortuna Gil, response.
Yes, Your Honor, the people would oppose any change in the exclusion zone or any sort of reduction. I believe that it's only a few houses away. So I think that it just makes it a bit difficult here. It's my understanding that the complaining witnesses as well as the defendant are all neighbors. So the people would oppose any sort of reduction in that exclusion zone for those reasons and due to the assaultive nature of the underlying crime.
Okay. Any response on the modification of bond motion, Ms. Rothstein?
Just that Ms. McClendon has no prior criminal history of assaultive or anything else to the best of my knowledge. And I think that it is a few houses down. If she was allowed to return home, she is willing to respect the no contact order. She told me she would even drive down the other side of the street to make sure she'd even drive past their house on her way to her home. Just that all of her things are there. She does have a 7-year-old daughter. They both have been displaced. They would like to return to their home to be able to sleep in their own beds.
All right, thank you. I haven't had the opportunity to see the affidavit on this 3 counts of assault with a dangerous weapon concerning pepper spray. I'm going to deny the modification of bond at this time. This can be readdressed in circuit court once the offer is taken. Once the once you decide what's going on with the file, it can be readdressed in circuit court. But at district court, I'm going to deny the modification of bond, mostly for the safety of the 3 individuals involved in the felonious assault. Because Ms. McClendon is on PR bond at this time, so she was left her own personal recognizance. I do have a no contact order with the 3 individuals, but no GPS on this case. Anything else? So your time in Ms. McClendon, your time in district court is done. You're off to get to circuit court where you get your next date of appearance from your attorney, Ms. Rothstein, and this can be readdressed in circuit court. Anything else for the record in docket 26-01298, Ms. Fortuna Gill?
Not for the people.
Ms. Rothstein.
No, Your Honor.
All right. All right. I'm going to sign the bind over documentation and you'll get your next date from your attorney, Ms. Rothstein. Ms. McClendon, you're all set. Thank you for your appearance today. Just want you left.
Nope, she's right here.
Oh,
She's just hiding.
here.
We should be ready to go on Glenn.
And Mr. Doyle's here on Barnes.
Yes, that is correct.
All
We're
right.
ready on that matter as well.
You call and I'll. So you want to go on Glenn?
Let's get Glenn.
All right. So Marquise Glenn. So it's my understanding that I'll be binding this over to circuit court and then I'll be taking a plea on this matter. Is that correct?
Yes, Your Honor.
All right. All right, so we're on the record in docket 26-01249. That is People of the State of Michigan versus Marquise T. Glenn. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Rothstein.
Peter Rothstein from the Ingham County Public Defender's Office, appearing on behalf of Mr. Glenn, who's present in the courtroom and seated to my right.
And sir, you are Marquise Glenn, is that correct? Okay. All right, thank you. This is the time set for a preliminary examination. We'll bind it over to circuit court, is my understanding, and then there's going to be a plea taken. Is that your understanding, Ms. Fortuna Gill?
Yes, Your Honor.
Ms. Rothstein.
Yes, Your Honor.
All right. So is there any offer you want to place on the record concerning this preliminary examination bind over, Ms. Fortuna Gill?
Yes, Your Honor. The people have extended the offer to plead to 1 count of resisting and obstructing arrest. That would be count 1. The remaining counts 2, 3, and 4 would be dismissed. Additionally, there is a sentencing agreement to HIDA.
And is that a fair statement, Ms. Rothstein?
Yes, Your Honor, it is.
All right. May I inquire of your client, Mr. Glenn, of his waiver of the preliminary examination?
Yes.
Mr. Glenn, you have a right to a preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Vita Rothstein, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court, and the offer has been placed on the record. Yeah. Is it still your wish today to waive your right to preliminary examination today? Yeah. Do the people also waive their right to preliminary examination today?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made based on the offer that was placed on the record. And I will provide the documentation for signature purposes for the parties. We already have a circuit court judge signing the file, right? Who's the just makes it easier. I think it's Stokes.
It is. just don't.
On what date?
No, second, 7/22.
Thank you, Sean. All right, so I'm in possession of the bind over documentation signed by all the parties. I'm going to indicate the examination was waived on today's date, which is May 28th, 2026. The bond is set at 2,500 PR bond. Anything else to come to the court's attention before I sign the bind over documentation, Ms. Fortunigo?
Not for the people.
Ms. Rothstein?
No, Your Honor.
All right, I'm going to sign the bind over documentation. And then it's my understanding we'll be moving to plea. Is that correct? Ms. Fortunigo?
Yes, Your Honor. And I do have the paperwork if you would like me to approach at this time.
Sure. Do you have a copy of the information? Because you'll be reading the
You mean the
information.
complaint?
Yeah.
I do have a copy of
Okay.
the complaint.
And it's my understanding that, and I'll cover this, but this will be in front of Judge Stokes for sentencing. Is that your understanding, Ms. Fortunigo?
Yes, Your Honor.
Ms. Rothstein? Is that your understanding?
It is out.
Okay, and it's set for, the sentencing is set for July 22nd at 9 a.m. in front of Judge Stokes. All right, I'm told the defendant would like the court to accept a circuit court plea from him today. That means the plea would be entered and accepted in this court, but the case will be assigned to a circuit court judge, and that's the one we just discussed. That's Judge Stokes would be assigned it for sentencing purposes on July 22nd at 9 o'clock. Is that your understanding, and do you consent to that? So a different judge would be sentencing you. I would be taking the plea. Is that your understanding, Ms. Fortunigo?
Yes, Your Honor.
Ms. Rothstein?
Yes, Your Honor.
And Mr. Glenn, is that your understanding? I'll be taking the plea, but I won't be sentencing you.
Yes, sir.
Okay, thank you. The court has already bound this matter over to circuit court. The formal information is being provided to you. Do you have a copy of that information for the defendant?
Your Honor, I have a digital copy.
Okay.
I can email it to either Marcy to have one printed out, or I can email one to defense counsel, whichever is easier.
Whichever is preferable.
I will email to defense counsel.
All right. So you are providing, you know what the offer is, and you're being provided information to that effect. Is that correct, Ms. Roston?
Yes.
And is that correct? That's your understanding, Mr. Glenn, that your attorney is going to get the electrical copy for our purposes?
Yes, sir.
All right. All right, I will let Ms. Fortuna Gill send that, and then we can read the pertinent parts of the information. So in relation to the information, he'll be pleading to count one. Is that fair?
Yes, Your Honor.
Yeah, it's my understanding is this will be a plea to the resisting, obstructing, and Ms. Fortuna Gill will read that into the record. The counts 2, 3, and 4 are going to be dismissed, and there's a HIDA agreement, a Killebrew agreement to HIDA. Is that your understanding, Ms. Rothstein?
Yes, Your Honor.
All right.
Okay, I do have the complaint up and ready whenever the court is ready, and a copy has just been sent to Ms. Rothstein.
All right. So read the pertinent parts of the complaint concerning the plea.
Thank you, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant did assault, resist, or obstruct a police officer on or about May 10th of 2026 at Martin Luther King and South Glen Ave, Lansing, Michigan. The defendant did assault, batter, wound, resist, obstruct, oppose, or endanger Trooper Dylan McPhee, a police officer of the Michigan State Police, that the defendant knew or had reason to know was performing his or her duties. Contrary to MCL
750.81 D (1). This is a felony punishable up to 2 years and or $2,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81 D(6) for another violation arising from the same transaction.
Okay, so it'll be the plea to count 1 and counts 2, 3, and 4 dismissed. Is that correct?
That is correct, Your
All
Honor.
right. And then there's a Killebrew agreement of that the defendant to receive treatment under HIDA. Is that your understanding, Ms. Fortuna Gill?
Yes, Your Honor, there is a sentencing agreement to HIDA.
Is that your understanding, Ms. Rothstein?
Yes, Your Honor, it is.
All right. Do you understand the count that has been read by the people?
Yeah.
Okay. Have you raised your right hand as best you can? Do you solemnly swear or affirm that the information you're about to provide this court be the whole truth, so help you God, under the penalty of perjury?
Yes.
This charge is commonly referred to as resisting and obstruction. Resisting and obstructing. And how do you plead to this charge, Mr. Glenn?
I plead to like walking or running away from the police.
All right, and so you plead guilty to the charge?
Plead guilty to.
Okay. And do you understand this charge carries a maximum possible penalty of 2 years and or $2,000? Do you understand that? All right, there's a sentence agreement, and if the sentencing judge was to do something different, you'd have the opportunity to withdraw your plea. Do you understand that?
Yes.
Okay. If you've been, are you on probation or parole, sir?
Am I on it? No.
Okay. If you've been convicted of a felony in the past, it may be affect the way you're sentenced by the sentencing judge or your HIDA status. Do you understand that? Okay. So these are the rights to be giving up by pleading guilty to the. They are the following: the right to have a trial by jury, the right to have a trial by judge, the right to be presumed innocent, the right to have the prosecutor prove beyond reasonable doubt that you are guilty, the right to have witnesses against you appear at trial, the right to have cross-examine those witnesses, the right to have a court order the witnesses to appear in your defense, the right to remain silent and not to have that silence used against you, and the right to testify at trial if you choose to testify. These were all incorporated in a device of rights that I'm going to add to the file, and you signed the bottom of this document. Is that correct, sir?
Yes.
Okay. Do you understand your misdemeanor? Do you understand your felony jury trial rights as I've read them to you?
Yes.
Okay. Do you understand that you will give up each of these rights if you plead guilty? Do you understand that? You also give up the claim that the plea was a result of any promises or threats that we've not placed on the record. Do you understand that, sir?
Yeah.
Do you understand that any appeal of your conviction and sentence would not be automatic? You'd have to ask for an appeal because you won't be having a trial. So you won't be having a trial today. So you'll have to ask for an appeal for any conviction to the Court of Appeals. Do you understand that?
Yes, sir.
All right. We've indicated that the agreements for the record. This is a count 1 plea, counts 2, 3, and 4 dismissed, and then there's a Killebrew agreement of YTA treatment. Is that correct?
Yes.
Okay. Is that your understanding, Ms. Rothstein?
Yes, Your Honor.
Is that your understanding, Mr. Glenn?
Yes, sir.
All right. Okay. Are you pleading guilty because you are guilty? Tell me what makes you guilty of this offense. It's resisting and obstructing of a Michigan State Police trooper known as Dylan McPhee. And you've already started to indicate. So tell me the facts of how you're guilty of resisting and obstructing.
Like tell you how.
Yeah, just tell me about the facts. Yeah.
Started to walk away and or run.
All right, you started walk away and or run, and you knew that you were walking from a trooper. He was dressed as a trooper. Is that correct? All right, and he was giving you a lawful order to stop, and you disobeyed that order.
Yeah.
Okay. So that's contrary to MCL 75081D. Anything towards a factual basis, Ms. Fortuna Gill?
No, Your Honor, the people are satisfied.
Ms. Rothstein, anything towards a factual basis? I should say it all occurred. We should say it all occurred on May 10th, 2026 at Martin Luther King Southland Avenue, or in that vicinity in the city of Lansing.
Yes, sir.
Okay. Anything, Ms. Rothstein, now that we've done the date and time?
No, Your Honor.
All right. All right. The court will affirmatively state that it is not agreed upon sentence with anyone involved in this case. That's the Killebrew agreement. The sentencing court will take a look at that. But if it's not followed, you'll have the opportunity to withdraw your plea from the sentencing judge. Is either counsel aware of any promise, threats, or inducements for this plea other than those disclosed on the record, Ms. Fortuna Gill?
No, Your Honor.
Ms. Rothstein?
No, you are.
Okay. Does the council believe the court has complied with Michigan Court Rule 6.302 and the local administrative order allowing a felony plea in district court? Ms. Fortuna Gill?
No, Your Honor.
I think you have to say yes on this one.
Oh, I apologize. Yes, Your Honor.
Ms. Rothstein, has the court complied with the court rule?
Yes, Your Honor.
All right. The court would find the plea to be accurate, voluntarily, understandingly made. The plea is accepted and transferred to Judge Stokes for sentencing on July 22nd at 9 o'clock. There will be a petition filed for HIDA, and that's what Judge Stokes, that's the main, because that's abstracted in a different way, and that covers this differently. Anything else for the record in 26? There's an order for DNA sample that would be signed by judge. I'll sign it here. I'll sign it right now, but it'll be, that might be taken before Judge Stokes does her sentencing, but I'll sign that on today's date. So that's May 28th. All right. I'm going to include the advice of rights. That's been, although I covered all the rights, the advice of rights is in the file and the plea agreements in the file. Anything else on 26-01-249, you'll get your next date. You'll be in front of Judge Stokes for sentencing on July 22nd at 9 o'clock. All right, sir? Yes, sir. Anything else, Ms. Fortuna Gill?
Not for the people. Thank you.
Anything else, Ms. Rothstein?
No, Your Honor. Thank you.
Okay, you should be all set, sir. Thank you for your appearance today.
We should be ready on Barnes. Are you ready on Barnes?
Here's the advice. On Seneca or Seneca?
Seneca.
Seneca.
Well, he was supposed to use the behavior.
What do you need? All right, so we're on the record. We can clear that up. We're on the record in 26-01-297. That's People of the State of Michigan versus Seneca Barnes. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Doyle.
This court, Dan Doyle, on behalf of Ms. Barnes, who's present and standing to my right.
And ma'am, you are Seneca Barnes?
My name is Seneca.
Seneca Barnes. Thank you, ma'am. This is the time set for a preliminary examination. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor. All the necessary witnesses required for this exam were present this morning. It's my understanding that the council wishes to request an adjournment. The people would have no objection to that, and we'll defer to Mr. Doyle.
All right, Mr. Doyle.
Yes, Your Honor, we are requesting an adjournment on this matter for further negotiation and in addition to get some additional discovery.
All right.
There is a misdemeanor offer, but there still need to be some things that need to be ironed out.
All right, there's no objection by the people to the request for adjournment. Is that correct, Ms. Fortuna Gill?
Yes, Your Honor.
All right. Is this a good cause adjournment, or is Ms. Barnes willing to waive her right to a prelim within 21 days of her date of arraignment? It has to if she doesn't waive her 21 days, she's going to get it in the next couple weeks. If she waives her right 21 days, it provides some flexibility.
Yes, we would need a waiver of the 21 days.
All right. All right. May I inquire of Ms. Barnes of her waiver of the 21-day rule?
Yes, Your Honor.
All right. Ms. Barnes, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Dan Doyle, and he would be present, cross-examine any witnesses or contest any charges brought against you at the prelim by the people of the state of Michigan. Is that your wish today to waive your right to a preliminary examination within that 21-day period? You wouldn't be waiving your right to a prelim in general, just within that 21-day period, so we can have some flexibility in scheduling. Is it your wish today to waive your right to a prelim within the 21-day period? Do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
Right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And then we can set this. What's our time frame? What time frame are we looking at here?
Yeah, I probably need at least 30 days. I don't
Okay,
know.
30 days, and then it's got to fit within your whatever trial schedule. So,
Yes, Your Honor.
all right. So I'm going to give you a couple dates, and you can look at your schedule.
First one, we look, and this is.
Yeah, it's set. Do you want to set for to leave on for prelim, or
We can do a PCC.
okay? So let's do a PCC 30 days out.
So that would be June 26th.
June 26th. How does that work with your schedule?
It does, Your Honor.
All right. So set it for June 26th at 9:30. 9:30 for PCC, and then we'll set the corresponding prelim for the following week.
Yep. That would be June. Oh,
We do July 10th for the prelim.
Yeah, it would be July 10th.
we- 1 week is
June
July 2nd.
26th.
Oh, no, we're not. It would be, prelim would be the 9th.
All right, so it'd be July 9th, because we switch days. So July 9th, does that work with your schedule, Mr. Doyle?
It does, Your Honor.
All right, so set it for July 9th at 9:30. All right, based on your waiver of 21-day rule, we've set probable cause examination, probable cause hearing for June 26th at 9:30. That can be attended via Zoom if you choose. And then the preliminary examination, which will be live in person, will be on July 9th at 9:30. Anything else for the record in docket 26-01297, Ms. Fortuna Gill?
Not for the people.
Mr. Doyle?
No, Your Honor, thank you.
All right, Ms. Barnes, you should be all set. Thank you for your appearance today. All right. You let me know, but we've probably got, I don't know. Do you have anything ready to?
We can go on Delton Jones.
All right.
Did you get my email?
Yes. Okay.
Oh, the defendant went to put money in the meter.
All right, we've got some time since the PCC is June 26th and prelim is July 9th.
There's gonna be another notice, Sean.
Maybe on Johnson. That I don't understand, but I do have a police officer, so it will be the armed causing injuries. So if we just did armed causing injuries on that.
There's gonna be another one, Sean.
So Johnson's putting money in the meter.
Or Jones's.
Jones's. Are you ready?
We probably need. a
We've
moment
got
to
some
speak with
time.
him.
So you can come get me when you're ready.
Okay.
Yeah. And that way, Marcy's gonna be able. Gotta catch your breath.
And just so the court is aware and Marcy's aware, I anticipate that Gomez is going to run
All right.
and that we would have 2 witnesses.
All right. All right. So we'll bring up Gomez after we move what we can.
Okay,
'Cause
and
that's gonna have a hearing.
yes, I do not anticipate any other
All right.
matter to run.
How about Timco? That's Miss Patrick's.
Yes, I anticipate that'll be a plea.
Okay.
Yes.
All right, just let me know and then let Sean know when to bring up Gomez.
You want to do it? You're ready?
All right.
Oh, well, we're ready on, so it's up to the court, whether
Yeah.
you want to take a break or
No,
if you
let's
want to
go
go
on.
on Johnson.
Let's go on Julian Johnson. All right, so we're on the record in 26-01-245. That is People of the State of Michigan versus Julian Johnson. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss Wanchi.
Melanie Wanchi for Mr. Johnson, who's at the council table.
And sir, you are Julian Santana Johnson, is that correct?
Yes, sir.
All right, thank you. This is time set for preliminary examination today. Miss Fortuna Gill, how we proceeded?
Yes, Your Honor, the people are unable to proceed on every count besides count 2 today. It's my understanding there will be a waiver of on count 2 alone and a dismissal of count 1, 3, 4, 5, and 6.
So 1, 3, 4, 5, and 6, and then a waiver on count 2.
Yes, and the people can fill out a nollie process just for the sake of making that a little bit easier,
Alright.
hopefully. And further for the record, the complaining witnesses were subpoenaed, reached out to several times without success,
Okay.
and they are not here today.
All right, so my understanding is that counts 1, 3, 4, 5, and 6 are going to be dismissed pursuant to a nollie process that'll be submitted by the prosecutor. And the waiver is as to count 2 only, which count 2 is the R&O occurring on May 10th, 2026 at 2418 Leesner, Lansing, 48910, with a waiver to count 2, that the witnesses were subpoenaed in this matter, and any contact to makes 1, 3, 4, 5, and 6, any contact has been unsuccessful in getting them here.
That is correct, Your Honor.
And is that your understanding, Ms. Wanchi?
It is, Your Honor.
All right. May I inquire of your client, Mr. Johnson, of his waiver of the preliminary examination?
Yes, Your Honor.
Mr. Johnson, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Melanie Wanji, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish to waive your right to a preliminary examination only on count 2. Counts 1, 3, 4, 5, and 6 are going to be dismissed pursuant to a nollie process that's going to be submitted by the prosecutor's office. So you'd be only waiving as to count 2, this preliminary examination, the one remaining charge. Is it your wish today to waive your right to preliminary examination on that count 2?
Yes.
Okay. Ms. Fortuna Gill, do the people also waive their right to a preliminary examination as to count 2?
Yes, Your Honor.
All right. I have, so I'm going to put that this is on in the notes that this applies, this bind over applies count 2 only. Counts 1, 3, 4, 5, and 6 are to be nollie processed. And I'll provide the examination, the documentation for preliminary examination for signature purposes to the parties.
I know, I'm sorry.
What's that? I don't know if Haley was gonna do the nollie on it or,
I will do the nollie.
okay, she's gonna do the nollie on that. All right, I'm in possession of the bind over documentation on 2601-245. It's been signed by all the parties. I'm gonna indicate the examination was waived on today's date, which is 5/28/2026. I've placed on this, that this applies to count 2 only. The remaining counts are to be nollie-prossed. Bond is set at $1,500, a cash or surety, and has been posted. Anything else to come to the court's attention before I sign the bind over documentation, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
I would like to address the data. They were related. He has a GPS data. It was related to the domestic part of the case, and since it's been there, all the domestic cases charges are being dismissed. We will also respectfully ask that the data is allowed to be removed at the court. Allowed the data to be removed.
Well, certainly no contact. I think we have no
And no
contacts.
contact also.
So, but that's not a part. It's just an R and O at this point in time. Ms. Fortuna Gill, any indication on the modification of bond?
No, Your Honor, the people have no position on bond,
All right.
considering the changes in charges today.
All right, I'm going, so. We'll set bond will set for the change in the modification or the change in counts that are bound over, and we'll set bond at 400 cash surety. $400 cash surety. So I'm resetting bond, I'm modifying bond to 400 cash surety. I would think that the no contact order can be lifted because there's no on the R and O. I would think that the no contact, so I'll lift the no contact order. It was no contact on Amanda Thomas. I'm going to lift the no contact order because she's no longer a victim. And then I am going to lift the GPS. As a part of the bond modification. So, Mr. Johnson, we will be responsible for contacting the private agency that's placed the GPS on and let them know that you're coming. I think they remove it at the same place they put it on, which is right next to the sheriff's department. All right. So I'm going to lift the GPS. And the no contact order. And set bond at 400 cash surety. So. Right, anything else for the record in docket 2601-245 before I sign the bind over documentation, Ms. Fortuna Gill?
Not for the people.
Ms. Wanji?
Nothing for the defense.
All right, I'm gonna sign the bind over documentation. Your time in district court is done. You're off to circuit court where you get your next date of appearance from your attorney, Ms. Wanji. All right, sir? All right, you should be all set. Thank you for your appearance today.
We have Mr. Jones.
Did you want to do
Yes.
Delton Jones?
I don't know that we have him back yet. I think
All right.
we need a brief moment.
And then how about Kaylin Timko?
Is she?
She's here. I didn't need to talk to her.
All right.
Okay.
And then, so We can probably bring up Mr. Gomez
Yes. I
for the
would think so.
prelim. All right, and for the meantime, and then you can come get me and let me know when you're ready.
Will do, thank you, Your Honor.
All right, so Theodore Gomez can be brought up.
Yes, sir.
All
All
right.
right. Hey. I am going to. Yes.
I think you need to sign this, don't you?
Yeah, I do. This is the page I was looking for. I think. 5.6. There you go. Is this where I say?
I have the video.
Yes.
Also.
To the sentencing agreement of Haida. It wasn't ever missing.
I just want to find out.
You need to get it from there. I need to get it from.
I don't know. That the defendant's information, I don't know why.
We're not giving you a copy.
Even though the client wants to have it.
Correct. We can give it to you.
So
You
who
can
do I get it
FOIA
from?
that. You FOIA it from the police department.
Okay, I'm going to check it now.
Freedom of Information Act.
Oh. Freedom of Information. Okay.
I was wondering what time she. Because,
Yeah. Yeah. No, I'm good.
They have ice cream in it.
They do, I know, I'm snuck one before, I'm okay.
Carrie, his girlfriend, told me that she sent me a copy, that she emailed you a copy of this video. I went, but she said that she. You didn't get it? No, okay. I can do that today. Gotcha. Okay. Oh, do you have a card? Thank you. So I'm gonna come by the office today on Washington, is that right? Is that where your office is? 2025 South Washington? One. One more favor.
No, I don't give favor.
Well, his dog, he's got a big dog, Rottweiler, and he was on the verge of death because he was severely underweight. And I wanted to show you, give you this phone to show him a picture, so you can see how
No,
good he's doing.
this is highly inappropriate. It's not gonna happen.
Okay, well, that's why I'm asking.
Yeah.
That's why I'm
okay,
asking.
you can go.
I
Bye-bye.
can go now?
Yeah,
Well, thank you.
you're welcome.
You may sit there. How about that? Oh.
To jump in and defend you. You're welcome. He wasn't leaving you alone. He was in here earlier and trying to get Dan and myself to, he was trying to engage with us as well. This is like.
good is you.
Yeah, he's on the phone out there. Well, I think
We are done, I believe.
yeah, we are done.
Yeah.
Is Mr. Jones back?
I'm calling you.
Oh, no, okay.
Do you need any help, Melanie? I can hang around.
I hope you didn't leave.
Huh?
That my plans didn't leave.
Yeah. You know, I have to ask for an adjournment anyway, so I'd be okay if your client left. I wouldn't ask for a bench warrant since he was here.
I filed a higher petition on Mr. Clinton.
Lovely.
One to your office, one to the floor,
Okay.
one to the Judge. I remember I always turned in 5 just to be sure, because I think it's 3, but
Better safe than sorry.
I will turn in, I always turn in more.
Okay.
So, all right, and then, I think we're set on him then. And then you're gonna ask maybe about, funded mental health.
Yeah, I will plant that seed for sure.
And I'm gonna talk to, there's a couple folks from our office who are on the mental health court team as well, and I'll talk to them about what needs to be done there as well.
Nice.
Just so I don't hijack you.
Cool. That sounds good.
Try to keep people informed.
I appreciate it.
When you go behind your back, you get upset. I don't know what that's all about.
Yeah, I have a general policy of try not to be an asshole. That's my policy.
We have a PCC tomorrow with, Guadalupe tomorrow.
Yes. Did I email you about that yet?
No.
Okay, I think it's because, yeah, I haven't been able to
What
victim consult on that. Yeah, so that's why I haven't given you an offer. So I anticipate something this afternoon because we've just been playing phone tag.
All right, okay.
The one in
Maybe
the back
that's
here.
not done. Let's see, I don't know.
Yeah. The one at the end of
All right, that
the,
one's on Zoom.
yeah.
You can come here in person, but
Yeah, but then.
Are you in just
Zoom,
someone's
and I feel like I
Right,
should be
it's
out
weird.
there. It's-
yeah.
It's
It is
weird
weird.
regardless.
When you get a phone.
All right.
All right, then have a good one.
You too, I'll see you tomorrow. Good luck,
Okay.
Melanie.
Thank you.
Okay, I will go let the judge know that we are ready. You said your client is here, Miss Patrick?
Yes, she's out in the hallway. I can get her now.
Lovely. Hi, we should be ready to. Okay. Yeah. Kind of some. Yeah. Oh. Yeah.
Yeah, because I hadn't had a chance.
No, that's
I don't know. Well, I don't know what it's every.
Yeah, well, he's here, so.
Yeah. He was just out there pacing. Okay.
Okay, thank you for letting me know.
No. I mean, if you want to email, yeah, then I'm cool with it. I wouldn't mind,
Some of them are big.
I have Dropbox too. I just paid for more, more storage. It's only 32% full.
I'm hoping it won't be longer than about a half hour.
There's a.
Oh, until we get to you, probably 15 minutes. Yeah. Did you need to take a break or go somewhere or
But you can
something?
have about, I can use. We'll try on it first. Since it's easy.
You can do that if you want. There's a vending machine on the first floor.
To try your own.
Yep, no problem. And I will only have one witness, not two.
Oh. So which one are we doing then?
Gomez is the one that's gonna go, but we'll call that last to get the others out of here. And I will have one witness.
So what one are we gonna do first then?
Well, we will probably do Mr. Jones
Okay.
first, and then Miss Timko, and then we will run the exam.
Okay.
And hopefully be done by noon. Megan always used to make sure we were done by noon, or she'd get mad at me, so.
Yeah.
On his way up, I just spoke to him, downstairs, next door. Yeah, they just called to bring him up. I was on the phone with him, and, he has something for me. He has a case in Clinton County that, because since he's been incarcerated, he missed the court date. So we need Clinton County to
I
understand.
don't represent him for the.
No, I understand that. So what I need to do, and he's gonna give you a letter to give to me, so I can take it to Clinton County to show them, so they can take the hold off. Because he has a hold. If they let him go, if the witness doesn't show up and they let him go, oh, he is here? Well. Okay. Good.
All rise.
Right, you can be seated. And Ms. Fortuna Gill, where are we? What case are we calling?
Yes, Your Honor, we can go on Jones.
Dalton Jones. Right, so we're on the record in 26-01-273. That is People of the State of Michigan versus Dalton Jones. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanchi.
Good morning, Your Honor. My name is Wanchi for Mr. Jones, who's at by my side.
And sir, you are Dalton Jones, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people would need to request a one-time adjournment. There has been an administrative error as far as getting a certified judgment of sentence for Mr. Jones to proceed on the prohibited person in possession charge. Of course, I do understand this is an error on the people, and I would be requesting a one-time adjournment for us to correct this error so that we can proceed on that charge. That being said, there is no complaining witness present on the other charges today. She was subpoenaed My office has had contact with her. I've had contact with her personally. And I would say that contact has been unsuccessful in getting her here today.
All right, so this is for count, I would think 3 or count 1.
Count 1, Your Honor,
Okay.
the prohibited person in possession charge.
Okay, request for an adjournment, Ms. Wanji.
You know, my client, we're ready to have the preliminary exam today. My client has the right to have it today. He's here, he's been here since 9 o'clock, so we will oppose the adjournment and ask for dismissal if the people are not able to move forward.
All right, thank you. Mr. Jones, the bond is set at 5,000, 10%, and Mr. Jones has made that bond, is that correct?
He has.
All right. All right, I'll grant the one-time adjournment. For continue, I would term this continued investigation, but it looks like you have to get the prior conviction here. This is a good cause adjournment, so Mr. Jones will not be waiving any of his rights today. Good cause adjournment. And then we will reset. Do you want it reset for preliminary examination or PCC, Ms. Fortuna Gill?
Preliminary examination, Your Honor.
All right. Is that a fair statement, Ms. Wanchi?
Yes, Your Honor.
All right. So it's a good cause adjournment. We'll reset the preliminary examination. What's the time? What's the time frame are you on the documents?
Your Honor, I would ask, I think we probably only need a week.
Okay.
I would ask for 2 weeks just so that we could get the subpoenas out if the court isn't going to dismiss the other charges today.
Right. So the 2 week, I'll reset it. We can go 2 weeks out or whatever the court schedule allows. Because I don't know how we look in 2 weeks.
We are really full.
All right.
And then follow the 3 weeks, we're off on prelim day.
All right.
So it would be.
All right. So June 25th.
Will the court consider dismissing the other charges since the alleged victim?
Yeah, they're not here, and I don't, but they are DV charges. So if I'm gonna wait and grant a one-time adjournment to see if they can get here. But this will be a one-time adjournment. So June 25th at 9:30. All right, we'll reset for June 25th at 9:30. Mr. Jones is not waiving any rights. This is a good cause adjournment. Anything else for the record in 26-01-273, Ms. Fortuna Gill?
No, Your Honor, thank you.
Ms. Wanji?
No, Your Honor, thank you.
All right, we'll see you on June 25th at 9:30. You should be all set, sir.
You're ready on Ms. Timko?
All right, so we're on the record in docket 26-01-045. That is People of the State of Michigan versus Kaylin Timko. Appearances for the record, Ms. Fortuna Gill.
Kaylee Fortuna Gill on behalf of the people.
Ms. Patrick.
Good morning, Your Honor. Melissa Patrick on behalf of Kaylin Timko, who is here to my right.
And ma'am, you are Kaylin Timko, is that correct?
I am.
All right, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Yes, Your Honor, at this time, the people are unable to proceed. We do not have the necessary witnesses required to do so. They were subpoenaed. My office, me personally, have tried to get contact with those witnesses and have been unsuccessful in doing so. I do anticipate a motion from Ms. Patrick.
Ms. Patrick.
That is correct, Your Honor. We are asking the court to dismiss the charges at this time.
Based on the prosecutor's representation that they did subpoena the witnesses, any contact to get them here has been to get them to appear. Once they've been subpoenaed, has been unsuccessful, and the people are unable to proceed. I'm going to grant the motion to dismiss without prejudice. I'll have that printed out. Thank you, Sean. All right, so based on the prosecutor's representations that they are unable to proceed, the witnesses were subpoenaed and any contact to get them here has been unsuccessful. This is made at the defendant's motion, a request to dismiss without prejudice, which is granted. I will sign the dismissal without prejudice. I don't have a GPS or no contact order. You can get a copy of this for your records if you want one. But without a contact order and without a GPS, it takes about 4 hours to purge from the computer system. I will sign. So this is dismissed without prejudice, which means that people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, ma'am? All right. Anything else for the record in 2601-045, Ms. Fortuna Gill?
Not for the people.
Ms. Patrick?
No, Your Honor, thank you.
All right, thank you.
Yes, thanks. It will.
Can I get a copy of that as well? Sure.
And then we brought up Gomez, right?
Yes.
All right.
I do just need an exhibit mark,
Okay.
and then you're ready to go.
All right.
I'll do that. Thank you.
Marcy, it's exhibit 1 is the flash drive, but it's gonna be A through C on the flash drive. And they are all videos, Ring camera videos from the same day. You don't have those?
No.
Oh.
I got her.
Thank you, Mr. Public Defense. Yeah, I think yes, the public defender hand him
He
something.
needs it for money. He doesn't have money. So I'll take care of it. Back to you.
It's open courtroom, but yeah,
That's like money.
right. All right, are we ready to proceed on docket 2502-426?
Yes, Your Honor, the people are ready.
All right, so on the record in 2502-426, that's People of the State of Michigan versus Theodore Gomez. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanchi.
Good morning, Your Honor. Melanie Wanchi from Mr. Gomez, who's seeking a defense favor.
All right, this is time set for preliminary examination day. It's my understanding that we're running the preliminary examination. Is there anything to come to the court's attention concerning this file, Ms. Fortuna Gill?
Yes, Your Honor, the people intend to call one witness, Mr. Carl Dean. That witness is present in the courtroom today. He is the complaining witness and the only witness we intend to call. Additionally, the people are prepared to admit 3 exhibits today. Those would be people's 1A through 1C.
All right. So so I will invoke the sequestration order. Your one witness is here going to testify. And then we've had the exhibits marked, and that's we've marked exhibit 1, and then it's got A through C on it.
That is correct.
Okay. Ms. Wanji, is there anything to come to the court's attention? I saw you removed a potential witness. Is that
Yes,
correct? Okay. So you both counsel know the case better than I do. If you see anybody who's not supposed to watch another witness testify, you can let me know. Sir, you may be a potential witness, so my understanding is you're to leave the courtroom.
I don't think I will.
We don't know, so I think that's why Ms. Wanji asked. We don't know if you're going to be a witness, but you have to leave the courtroom.
Okay.
Okay.
So
So I'm not asking you any questions or anything. You just have to leave the
I
courtroom.
understand how a drug dealer could be a witness against him.
All right. Thank you for that. You can leave. Okay. All right. So this is to protect the record and to have not one witness look at another witness's testimony. Tell me if I need to invoke the sequestration order. Ms. Fortuna Gill, you may call your first witness.
Thank you, Your Honor. The people called Carl Dean.
Actually,
Yeah.
All right, Mr. Dean, you can stand right in front of me and please
Oh,
state your
German.
first name and last name and spell them both for the record.
say that over.
Say your first name and last name and spell them both for the record.
Carl Dean, CARLD.
Please raise your right hand, sir. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Right, you can have a seat. The microphone is for, it doesn't amplify your voice, so please project as best you can. And Ms. Fortuna Gill, when you're ready.
Thank you, Your Honor. Good morning, Mr. Dean. Thank you for being here today. Do you recall July 7th of last year? Okay, can you tell me what is significant about July 7th of 2025 to you?
That day I got ran over twice. I could have got killed with it. I got surgery on my leg and everything on my foot.
Okay, and I'm gonna ask a few questions about that. The surgery, did that take place on the 7th too, or was that later?
That might have been either the next day, or probably like 2 days later. To get it done.
Sure, so you're not sure the exact date, but pretty close, within a few days? Okay. And you said that you got ran over twice. Can you elaborate where you ran over, what with?
I can't remember if it was a van or a truck.
Okay.
'Cause I have problems with my memory. They're tests for me.
Okay, and can you tell me when those problems with your memory started?
After I had got hit by the car, after Theodore.
Okay. And can you tell me, you mentioned Theodore, can you indicate, was it Mr. Gomez that you were referring to, Theodore Gomez?
We call him Teddy, but yes, Theodore Gomez.
Okay, and how long have you known Mr. Gomez? Do you know?
Maybe 2 years, about 2 years or so, 2 years.
Okay, and what's your relationship like? Are you friendly, not so much, something different?
I met him through my cousins.
Okay.
And we all drank, so we used to drink together, and then like we had problems off and on. 'Cause he gets drunk and likes to fight with people.
Okay, so you two have had problems in the past, is that correct? Okay. And can you tell me a bit about how the day began when you got ran over, if you remember? Do you know where you were before?
Before I got ran over?
Yes.
Well, I had walked from my house on Cleveland. It was a nice day, and I walked to my friend Sal's house a couple blocks down. I don't know the exact street.
Okay.
And I was over there visiting him and his girlfriend. And I was in the house, and then Theodore come in talking about you're a piece of shit and this and that, and I should whoop your ass. I should beat your face in and kill you dead with a sledgehammer.
Okay, so sorry to cut you off. I just want to ask a few follow-up questions about what you just said. Is that okay? Okay. So it's your understanding that Theodore came into the house, you were already inside?
Yeah, that's right.
Okay, and he walked in right away and started threatening you, or
Told me how much of a piece of shit I was, and then he wanted to beat my face in with a sledgehammer, run me over dead, and I told my friend I would come back. I was gonna leave and I'd just come back later to avoid the confrontation, and I left out. I left out to leave, go home.
Okay, and do you see Mr. Gomez in the courtroom today?
Yes.
Can you tell me something he's wearing?
Yeah, the glasses and the county jail outfit right
Okay, Your Honor, at this time, I would like the record to reflect that the witness, Mr. Dean, has identified the defendant as Theodore Gomez.
Any objection to the witness identifying the defendant for purposes of prelim as Theodore Gomez sitting next to you, Ms. Wanji?
No, Your Honor.
All right. Without objection, the witness has identified the defendant for purposes of prelim.
Thank you, Your Honor. Okay, Mr. Dean, back to the house that you were visiting, your friend's house. You don't remember the address? Is that what you said?
No, it's all on a police report. They got video cameras from tape from all of that.
Right. So do you remember making a statement to police?
Yeah, I talked with police.
Okay, if I showed you a copy of your statement to police, would that refresh your memory on the address?
I can't say yes or no, because I don't know the address.
If I showed you a copy of what you told police that day, the statement that you had with police, do you think that might jog your memory?
The address?
Yes.
I mean, if the police has got the address on the paper, it must be true, but
Okay. Your Honor, at this time, I would ask to approach the witness with his statement to police for the purposes of refreshing his memory.
Any objection to the witness refreshing memory, using the police report to refresh memory? Do you have a copy of that, ma'am?
Yes, sir.
Okay. All right. You may proceed with the refreshing of the witness of the memory.
Thank you, Your Honor. Also let the record reflect I am showing defense counsel. It's just highlighted his statement.
I just actually need the street name and I'll be able to tell you yes or no.
Okay. I am gonna hand you this document. And you are welcome to look it over for as long as you need. If your memory is refreshed, just let me know. I'll take the document back from you.
Yes. It's like a little, almost like a little alley street.
Okay, I'm gonna ask you again. So do you recall the address or the street that your friend was staying, that your friend's house was on? Can you tell me it now?
I don't know the address, the Fern Hill.
Okay, Fern Hill's the street. And is that in the city of Lansing?
Yes.
County of Ingham?
Yeah,
So state of Michigan.
it's right off of Cesar Chavez.
Okay.
It's right, either one, it's the same street, Cesar Chavez.
Thank you. Okay, let's get back into the assault. So you had mentioned that you left your friend's house. Did you end up leaving?
What, my friends?
Yeah, or you mentioned that you said you were gonna leave. Did you end up leaving?
I said I was gonna leave. I walked out the door and I walked up to the van and I looked in there to see if I seen that sledgehammer. And I walked away. And as
Okay.
I was walking away, he ran out the house, started yelling at me, jumped in, backed up, turned around, hit me, and it hit me.
Okay, and did you happen to see a sledgehammer in there?
I did not. I looked through the front window. And
Okay.
I tried to look down. I did not see no sledgehammer.
Okay, and when he hit you, do you remember where exactly he hit you?
The first time I got hit, felt like I got hit all right here. And that's when I went flying because there was a hill. There's a
Okay.
store. And like the alley on the side right here. So I didn't want to run towards the store because I didn't want kids or nothing running out. And maybe get
Sure.
hit. And there's a brick wall. So I couldn't run that way. So as he was coming, I grabbed like a little rock and try to throw it at the vehicle and he stopped to stop him. And he stopped and he hit the gas again and he hit me right here on my side and I went flying and it was like up over a hill. So when I landed, I don't know, I landed like this on the back of my head. And he drove down the hill and I was pinned in between his tire and a big rock. I had to like pull my foot up.
Right. So just for the record, you had indicated that you were hit initially on your right side.
Yeah, right.
Yeah.
Yeah, like pretty much right here.
Okay. And the second time that Mr. Gomez hit you, you indicated that he drove towards you. Can you tell me a bit about how far you think that he had to drive out of his way to hit you the second time?
But once he hit me the first time, he kept coming down he hit me, I went flying, and then he come down the hill. So, probably like, maybe if this was a hill, but then probably possible.
From me to you?
Where you were at.
Okay.
I
And
would say about 15 feet, 10 feet.
Yeah.
I
10 to
think that's
15.
fair. Okay, thank you for that. I know that those estimates can be hard, especially in such a traumatic moment. Now, would you recognize a video of the beginning of that incident if I showed it to you?
Yeah.
Okay, you've seen that video before?
I haven't seen any of the videos.
Oh, you haven't seen this video before? Okay,
The police went down.
okay. But you would recognize the surroundings in that video. You'd be able to tell me if that video was true and accurate.
I know exactly what happened, so yeah.
Okay. Your Honor, at this time, I would ask to approach the witness for identification purposes at this point to lay the foundation for People's Exhibits 1A through 1C.
Okay, so you're gonna show him, have him recognize the video.
The still from the video to make sure he recognizes the occurrences happening in the video.
You may proceed.
Let the record reflect that I am showing opposing counsel. Sorry, I didn't shoot well on this one. Does this look like a fair and accurate representation of outside of your friend's house that day, Mr. D?
Yep, and I would actually walk out this door, and I went to that door to check
Okay.
see if the thing was there, and this is where he backed out real fast.
Okay, so it doesn't appear to be tampered with or altered in any way. This is what it looked like that day to you.
There's tread marks right behind it, where that truck is really backed up.
Okay. And for the record, that was People's 1A.
Okay.
Now, I am showing the witness People's 1B. It's all the same situation, just cut up into different videos for the same purpose of identification. Okay, and does that look like outside of your friend's house that day?
Yeah, she's actually looking at, he had just hit me.
Okay, so this looks,
That's why she, yeah.
and that doesn't appear to be tampered with or altered in any way to you? Okay. And last.
Because when I was crawling back to their house, I remember her standing on the porch already crawling.
Okay, and then People's 1C, same ring camera. Does that look familiar to you, Mr. Dean?
Oh, yeah, let me see.
Absolutely.
All right, so that house is right next to the store.
So this looks like a fair and accurate depiction of that day,
So,
and it doesn't appear to be tampered with or altered in any way to you?
no.
Okay. Thank you. Your Honor, at this time, the people would move for admission for what has been marked as People's Proposed Exhibit 1A through C.
Any objection to the motion to admit People's Exhibit 1 with A through C videos on it, Ms. Wanji?
I have some questions, Your Honor.
Okay, you may proceed. Dean Vlad, you're the witness.
Yes. Mr. Dean, you said that you you have not seen those videos.
What?
This is the first time that you're seeing.
Yes.
Okay. You're not the one who took those pictures.
No.
And the only thing that you can say is that it looks familiar, but you don't know if someone changed anything on the video.
Well, I wouldn't know because I know what happened.
No, I'm not saying that. I'm talking about the video. What is on the video? You're not the one who took it, correct?
Okay.
And you don't know if someone manipulated or not. Is that correct?
Right.
Okay. I would oppose the admission of the video unless the person who took it can come.
But the foundation's been laid that the item is what it purports to be, A through C. I believe that any cross-examination concerning the actual events we're going to see would be that the witness would be subject to that cross-examination also. So I'm going to move to admit Exhibit 1A through C into admission. Anything else for the record? Anything else for the record, Ms. Fortuna Gill, concerning the arguments over People's Exhibit 1?
No, Your Honor, thank you.
Ms. Swanji, anything else you want the court to consider?
No, Your Honor.
Okay. All right. So People's Exhibit 1 is admitted into evidence. Only A through C as the foundation was laid, and you may publish.
Thank you, Your Honor. That was going to be my next question. Say I may publish, but do I have the ability to publish?
You do. I don't know if it'll work, but
I mean, do I have the talent, the skills to publish? Let's see. Duplicate. There we go. And this is that same video we were talking about, Mr. Dean? That first one, okay. And I am gonna.
so for the record, this is an indication. I think it's timestamped May 28, 2026. It's A of Exhibit 1, and we're not listening to sound.
That's correct. That's correct, Your Honor. Except the date is
July 7th.
Yes.
July 7th
Of
at 1932.
2025. Yes. And where I paused it, Mr. Dean, can you tell me who that individual is?
Yes, that's me looking for the sledgehammer through the window.
Okay. Here's that it has froze. I'm just gonna go back a few seconds. With hopes it'll catch up with us. Okay, it may need a minute here to buffer. Okay, let's see. It's frozen again. Okay, so while I let this buffer, I'm gonna ask you a few more questions, if that's okay, Mr. Dean. Because it is loading, it just appears to be loading pretty slow. So, after you were hit, what were your injuries?
Hospital for
Yes.
my left foot.
So it was your left foot that was ran over the time you were hit the second time?
Yeah.
Okay. And did Mr. Gomez say anything else at all, maybe through the window or anything while this was going? Not that you know of. Okay, but in the house, he did say that he wanted to run you over dead?
Yes.
Okay. And so, do you remember what was wrong with your left foot?
It's all shattered. My Helios, everything. I got like 4 or 5 screws and
Okay. And how many surgeries have you had on your foot?
one, and I'm getting ready to get another.
Okay. And did you ever have any issues with that foot before?
No.
Now, can you tell me a bit about how this incident has impacted you?
Well, I've been lately just like stressful. I can't like pay child. I can't take care of my daughter. All kinds of stuff.
Sure.
I've already been locked up once already.
I understand. Thank you for sharing that with us. I'm going to try to play the video once more. And who is that, Mr. Dean, who just walked out of the house?
That's Theodore Gomez.
Okay.
I'm walking home now. Trying to leave.
And so right there where the vehicle goes out of frame, can you tell me exactly when it is that you were hit, if you remember?
I know when he got out farther, I stopped and when come towards it, I stopped and grabbed a little rock, threw it at the window.
Okay, do you know, did that occur maybe one house, two house?
So, it would have been.
It's okay if you don't know, Mr. Dean. Would it have been about a block or more?
That ain't even a block, man.
Not even a block?
That whole street ain't no block.
Okay, that street itself was
like
very short.
From this house, when he pulled out, where you can't see the camera, we were already pretty much probably past the last house on this side. So that's about the only house you'll be able to see on this house. And the rest is the store right here.
Okay, so it's all a very short street.
Yeah.
Okay, understood. About less than your standard city block. Is that right?
Yeah.
Okay. And then this is people's 1B. Maybe. Hopefully. And do you know who these people are?
Yeah, that's my friend Sal. That's girl Kylie.
Okay. And do you know, is this over here in the corner, Mr. Dean? Do you know who this is?
See that far?
You can't see that far?
That might have been me crawling.
You said you did crawl back?
Yes.
Okay.
And he was going to actually, because she was standing on a porch and she was like, oh my
Objection.
Huh?
Yes.
What?
There was an objection, so Your Honor, I will redirect the witness.
All right. All right.
So
So the
we-
objection's sustained.
So we can't say anything anybody else said besides Mr. Gomez and yourself. That's all. So I'm gonna continue playing the video. But and so this is your friend, your friend, you said, Mr. Dean? And you can't quite tell if that is you in the video.
Oh, that's me.
That is you in the video. Okay,
If that's a person on the ground, that's me.
okay. But
I can't see that. I can't
Sure.
see that far.
and that's okay. If I approach closer with the exhibit, do you think that might change things? Your Honor, may I approach the
You may.
witness? So same exhibit that's on the screen here. My screen is the same. It's still very
Yes,
small. So
that's,
just
that's me. I crawled up there and I'm holding my foot up like this,
okay.
up towards my chest area.
So after you were hit, you crawled back to your friend's house?
I almost made it there and then he was getting off the porch just to get in the truck and pick me up. Just, that's what he was doing.
And when you say he was getting off the porch, who are you referring to?
So,
Okay, so that's your friend. I have no further questions for this witness at this time. The people would move to admit peoples 1A and 1B. The people are not going to move for admission of 1C at this time. It is very similar to 1A and 1B, and I don't believe it would be worth the court's time to go through loading video.
All right. All right. So redirect Ms. Wanchi.
Thank you. Good morning, Mr. Dean. So you saw yourself in the video
yes,
walking toward the car.
yes.
Now you say you don't seem to be very steady on your feet, correct?
No.
You walking like you are limping a little bit.
No.
Okay, you said that you admitted earlier that Mr. Gomez is your drinking buddy, or that you used to drink with him.
Yes.
And on that day, did you drink?
No.
And so when we see you on the video and you walking not very straight, why is it?
It's called a pimp walk. You know what that is?
No, explain to me what the pimp walk is.
Well, a little swagger, a little limp to your pimp.
Okay. And why were you walking like that?
That's how I like to walk.
Okay.
I
And
think
when,
it makes me look cool,
okay. And when you say that on the day of the incident, when was the last time you said that you were a drinking buddy with Mr. Gomez, and that your what was we used to drink together. When was the last time you drank with him?
Oh.
You don't remember. That's okay.
It's been that long.
Okay. You testified that when Mr. Gomez, you saw his car coming toward you, I
Yes.
suspect you took a rock and
Yes.
threw it into his windshield.
Yes.
Did you break the windshield?
Yes, I did.
Is it possible that by you breaking the windshield, you caused him not to be able to see where you were going, what was
No.
going on? Right there. But it was very fast, correct?
What's that?
The incident, what took place, it was fast. Okay, when you broke the windshield, was he able to stop?
No.
Okay, he was
He was
driving.
already coming after me when I threw the rock through his window. That's the only thing that made him stop.
Okay, so you threw and by the time when you threw the rock into his windshield, he had not touched you yet.
He stopped.
Okay.
And then ran me over.
But you were the first person who threw the rock to his windshield, correct?
Yes,
And when you did that, he had not
in
touched you
the
yet.
process of running me over, that's the only
Okay.
way I had to defend myself.
Okay,
I
but you
had
don't,
a van coming at me.
okay, but you don't know whether or not.
I do know. You see
Can
how
you- sir,
he
can
said he
you-
was gonna hit me and run me over.
Can you let me ask you the question, please? I understand that it's, but, okay. You said that he told you that he was going to run you over. Is that correct?
Yes.
He said that. Did you talk to the police that day, correct?
No.
Or the day after?
Yes.
You did not tell the police that he made that statement, is that correct?
I told him I yes.
Okay. There was, Mr. Sal, who was there when he said that?
So, a mother, Kylie.
Okay. Is it fair to say that Mr. Gomez and you are, what kind of relationship you had?
What do you mean?
Were you good buddy? Did you had some issues
No,
together?
no. I met him through my cousins, which he was their friends, and
What-
he would drink with them. I might show up at their house and they're drinking. I might drink a beer or so. We weren't friends like that.
Okay. Do you recall when you went to his home and threw a rock to his window?
I never threw no rock through his window.
Never happened?
It never happened.
Okay. What's your cousin's name?
Which one?
The one to whom you were able to meet Mr. Gomez?
Jacob Severy.
Okay. And how long after you met did this incident take place?
Probably years after, I don't know. It
Okay,
didn't happen right away.
okay. Do you remember telling the police that you had a fall up, that you used to be friends with him, but you after that, you became you separate, well, you had a fallout and just became friend again? And
I can't understand you.
did you recall telling the police that you used to have a fallout with him, that you guys had some disagreement?
Yeah.
And that on the day that you saw each other at Sal's home, you had made up, you were friend again, is that correct?
No, I didn't say we were friends or anything like that. I said I didn't know we had any type of problems.
Oh, okay. So you're telling the court that you did not have any problem with Mr. Gomez, and when he came to Mr. Stuart Sal's house and started threatening you?
At the time, I did not know we had no problem.
Now, when you went outside, I suspect you tried to look into the window and you did not see any sledgehammer, correct?
No. Not right in the front, but I was gonna open up his van, open up his truck. And look through it.
I understand that, but you did not see anything.
No.
You said that you had some memory issue.
Yeah.
is it possible that the memory issue was caused by the drinking?
No,
Is it possible that the memory issues was caused by you using drugs?
no.
Do you use drugs?
Objection, Your Honor, relevance.
I don't.
Response?
You know, I think that I asked him, he said no, so.
I mean, if you have your answer, but I don't think there's anything on the record that he was using drugs that day.
That
So-
day,
There
So-
is not.
All right, without that of the objection sustained.
I would rephrase it. Mr. Dean, when you said that you were hit, you did not, and how did you, when you were hit, how did you fall down?
Huh?
How did you fall?
How did I fall?
Yeah.
I went flying through the air. I didn't
Okay.
just fall down. I went flying through the
What
air
did
and
you fall?
landed on
Okay, did you hit your head?
my head and my back.
Your head and your back?
And my buttocks.
Okay, your buttocks.
Yeah,
Okay.
yeah,
Did you hit your head?
yes. So I'll be on video.
You have a video of what?
They should have had video of everything.
We should have.
I'll get another video for you. You can see me go all through the air. I don't understand all this, everything on video.
Do you have videos of the event?
You guys should have every video. If not, I'll get another video for you guys
Thank you.
from the store.
Okay. I have no further questions, Your Honor.
Redirect Ms. Fortuna Gill.
I have no further questions for this witness, Your Honor.
May this witness be excused from the people, Ms. Fortuna Gill.
Yes, Your Honor.
Ms. Wanchi.
Yes, Your Honor.
All right, Mr. Dean, you're all set. Thank you for your appearance today. And Ms.
Thank you, sir.
Fortuna Gill, any further witnesses or evidence today?
No, Your Honor. The people are ready to move for bind over.
All right, people rest. Ms. Wanji, any evidence that you're putting in today at prelim?
No, Your Honor.
All right, all right.
I'm just making
I
it
we
real
will
easy.
talk. We will talk.
Right.
We will talk.
All right, motion for bind over when you're ready, Ms. Fortuna Gill.
Yes, Your
Maybe I
Honor. You
drunk
are
them all,
welcome
like
to
this.
listen to this. You're welcome to listen to this, or you're good to go, whatever you want. Okay, my apologies, Your Honor. Yes, the people are ready to move for bind over. So the court is aware, based on the way testimony came in, I did speak with Ms. Swanji about how, depending on how testimony came in today, the people may be seeking bind over on more severe charges. That is going to be the case based on the way testimony came in today. Of course, I couldn't have been sure exactly. The people are going to be moving for bind over on assault with intent to murder. The PAC code for that being the PAC code for that being 750.83. I will go through the elements. The first element being that the defendant, Theodore Gomez, tried to physically injure another person, that other person being Mr. Carl Dean. The second element is that when the defendant committed the assault, he had the ability to cause an injury, or at least believed he had that ability. And the third is that the defendant intended to kill the person he assaulted. And that is the third element. So the people would be moving for bind over on this alternative higher charge. It's currently charged as a felonious assault. We heard testimony today from one witness, Carl Dean. He indicated that he was at a friend's house, that friend's house was on Fernhill Street, that was in the city of Lansing, County of Ingham, state of Michigan, making this court the appropriate venue for this case. Mr. Dean did identify Theodore Gomez as the individual who ran him over twice. And he also noted that this was on July 7th of 2025. As far as the elements for assault with intent to murder go, we do know that Mr. Gomez did try to physically injure and did actually successfully physically injure Mr. Dean, that he was hit with his vehicle twice. once hitting him in the right side. We heard testimony today of that. And while we do not have a video of the actual collision, we do have a video of Mr. Gomez getting into his vehicle and following Mr. Dean, just as Mr. Dean testified to the events happening. Essentially, we know that before Mr. Gomez followed Mr. Dean in his vehicle, he threatened to kill him, that he threatened to beat him up, that he said, quote, that he would run him over dead. We heard testimony of that today from Mr. Dean. Additionally, there's a statement that Mr. Gomez had that threatened to kill Mr. Dean with a sledgehammer. So there were lots of threats to kill before Mr. Gomez followed Mr. Dean in his vehicle and then proceeded to hit him not once, but twice in that vehicle. So the element that he had the ability to cause the injury, he certainly did. We saw him get in the vehicle himself and follow Mr. Dean. And I would argue that his statements partnered with hitting Mr. Dean twice, the second time while Mr. Dean's already on the ground, running over his left ankle and shattering his ankle while Mr. Dean was pinned, essentially, that is the intent to kill to a probable cause standard. If the court is not satisfied with the elements of assault with intent to murder, the people would, in the alternative, move to bind over on 2 counts of assault with intent to cause great bodily harm. The first being the first hit, the second being the second hit with the vehicle. So people request bind over on assault with intent to murder, but if the court is not satisfied with that, we would request bind over on 2 counts of great bodily harm.
Thank you. Response, Ms. Wanji.
Thank you, Your Honor. Your Honor, there was testimony that Mr. Dean was the one who assaulted first. He said that he took a rock and threw it through the windshield. When someone is in a car and he's driving and there is a rock which is thrown into the windshield, I would say that would cause the accident. He said that Mr. Gomez threatened to kill him with a sledgehammer, but there was no sledgehammer. No sledgehammer was found in the scene. There was no testimony that whether that day or when the police was there, that there was a sledgehammer that was found around the place. So that was ever found there. So we don't believe that there was a specific intent to kill, and that Mr. Gomez had the intent or the belief that he had the opportunity or the intent to kill. Second of all, the injuries. The testimony from Mr. Dean was that the car ran over his foot, his left foot. If Mr. Gomez had the intent to, and it's when he fell that the car ran onto his left foot. So we don't believe that, we still believe that what caused the incident was Mr. Dean throwing a rock into the windshield, and that what caused the incident. There was no intent to injure. There was maybe, if we want to believe that there was some threats, the fact that there was no, there was the threat of hurling with the sledgehammer, the fact that there was no sledgehammer showing that there was just a empty threat and there was no opportunity to injure on that basis. So we will ask the court not to bound over on any of the counts.
All right, thank you. Response, Ms. Fortuna Gill.
Briefly, Your Honor, just that, any issue of self-defense, of course, would be a question for the trier of fact. And I think that, of course, I could go into that. I don't want to waste the court's time, but I certainly don't believe someone throwing a small rock that would necessarily justify being ran over not once but twice. So I would just like to say that for today's purposes, we're looking at a probable cause standard, and I think any issues of self-defense would be for a trier of fact and not for today's purposes. Thank you.
Right, thank you. The standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. This all occurred, the events, according to the testimony of Carl Lee Dean, that happened in the city of Lansing, 48906, 110 Fernhill Court, but it was in the city of Lansing. And there was so I've heard Carl Dean, and then I've seen exhibits A and B concerning this matter. So location and date are met at a probable cause standard for this all happening in the city of Lansing at Fernhill on July 7th, 2025. The defendant was identified by Carl Dean in the courtroom, and the venue is the city of Lansing, Union County, state of Michigan. So I find all those are met at a probable cause level. The elements of the crime based on Carl Dean's testimony, and then some of the ring camera footage on A and B that the court was that was moved for admission. I find that that count 1, assault with a dangerous weapon, I'm going to be changing that to count 1, and that would read 750.84, assault with intent to do great bodily harm, less than the crime of murder for count 1. In that, the defendant did assault with intent to do great bodily harm or less than the crime of murder. Carl Dean, but without intending to commit the crime of murder, he meant to inflict great bodily harm, less than the crime of murder. This is a 10-year felony, not more than $5,000 for costs. So that's in count 1. And in count 2, I'm going to bind over on 750.84. That's assault with intent to do great bodily harm, less than the crime of murder. In that, Theodore Gomez did assault Carl Dean, a person with intent to do great bodily harm, less than the crime of murder. And that was all done on July 7th, 2025 at Fernhill Court in the city of Lansing. The premises was it happened in the street. So it happened while I was driving. It didn't actually happen at the address. It happened at the street. So I'm going to put the Fernhill Court in the city of Lansing. I'll bind over on assault GBH 750.84, count 1, and count 2, 750.84 on count 2. So you've had your preliminary examination based on, and the court's been able to hear the preliminary examination. I'm going to indicate that the examination was held on today's date, which is May 28th, 2026. And it was found that probable cause exists to believe both that an offense was committed and the identity of the person who committed that crime. I'm gonna amend the charges on the complaint, and it'll read count 1 and count 2 are bound over on assault GBH. Based on the testimony and some of the exhibits. The bond has been set at $25,000, 10% based on the felonious assault, count 1 of the felonious assault. Before I actually bind the case over and sign the bind over documentation, did you want to be heard on bond, Ms. Fortuna-Gill?
Yes, Your Honor.
You may proceed.
Your Honor, given the testimony that we heard today and the bind over on 2 charges that are more severe than the initial charge, we're looking at 2 10-year felonies now. The people would requests an increase in bond at this time due to the increase in the violence of the offenses.
All right. Ms. Wanji, on bond modifications.
Thank you, Your Honor. The only thing that happened today is that there was a probable cause to believe that that a more severe felony took place. My client still had the right to remain to be still have the right to he remain innocent until proven guilty. The same circumstances, he has not violated it. I know he's in jail, Your Honor, and we believe that the other conditions that would be put in place to protect the alleged victim can be put here without increasing the bond amount. We have been trying to have the court lower the bond for twice already, or once. And we believe that we still believe that the bond is high, he's indigent, and that there are other measures that will be put in place to protect the alleged victim and protect the society. And so we're going to renew our request to lower the bond. My client has been in jail since 3 weeks.
32 days.
32 days. This offense took place back in July of last year, July 7, 2025. So it's and since that time, my client has not had any other charge. We do believe that the bond is very high, and would ask the court to either leave the bond to the amount that it is now or to lower that bond.
All right, thank you. The bond was set by the I think that was, Judge Ward? I think Judge Ward set the bond on the assault with a dangerous weapon, the felonious assault 4-year. There was a request at that time that the bond recommendation from the prosecutor's office was crime charge involved violence. A defendant has a history of violence towards a victim, history of threatening behavior, threats to kill the victim, escalation of violence. And they requested a 10,000 cash surety bond with GPS tether and 2,000 square foot exclusion zone, and then some conditions of bond. Bond was set by Judge Ward at 25,000, 10% on the felonious assault. So the same bond conditions still are a part of the file. That if you're able to make bond, GPS is ordered. No use of alcohol or drugs, or no use of alcohol or drugs or marijuana. No assaultive behavior. Not a straight travel. No contact with the victim, Carl Dean. No possession of a firearm, and report to pretrial services within 48 hours. The bond was set at 25,000, 10%. That appears to be an excessive bond. The request was for 10,000 cash surety bond. However, the defendant's been bound over on 2 counts of assault GBH, which is each count is a 10-year felony. So I will modify the bond, and the bond's modified per the counts charged, and then to also reflect that both charges that were bound over were raised to a 10-year assault GBH, and I will bind over on 2 counts at $30,000 cash surety. For the 2 counts, bind over on assault GBH, the 10-year. So it's set for $30,000 cash surety. That's $15,000 a charge for the 10-year offense that the defendant's bound over on count 1 and count 2. So I'll change that to 30,000 cash surety. And I'll sign the bind over documentation of today's date, May 28, 2026. Indicating this is bound over on 750.84. 2 counts of assault GBH, the 10-year offense. Anything else for the record? So your time, Mr. Gomez, is done in district court. You'll be off to circuit court where you get your next date for appearance from your attorney, Ms. Wanji. Anything else for the record in docket 2502-426, Ms. Fortuna Gill?
Not for the people, thank you.
Ms. Wanji.
Nothing for the defense.
Okay, Mr. Gomez, you're all set. Thank you for your appearance today. And then Ms. Fortuna Gill, and I think that does, the prosecutor and the public defender are both finished today.
Yes,
I have a bench trial this afternoon.
That'll be fun. I always try to finish by noon. I know that's what Megan likes, so I still do my best.
All right.
All right, thank you, Your Honor. I will see you tomorrow
All right.
morning. And I think next week's my last week in here.
Yeah, they got you on off your feet.
Yeah, I tried to stay as long as I could. Next week was as much as I could get.
All right. Well, good luck to you, Ms. Fortuna Gill.
Thank you. We can talk out in the hall.
So how long is the circuit court? So I'll make sure you get the evidence of what's that. You just sit here and bring all bring all the freaking, bring it. But see when he was all out, and they don't even show it. It was had to been once right after he took it out. So that has to come back. So that's just have to prove that because it was just one thing. I know, but I didn't know that this was gonna be like this. But he threw the freaking rock, so it's not, how is that not any worse? I still have the rock that was there too.
Okay, but so we need that. And that would have been something to people in the police or even if you like to us. So you can do it, but you know, and plus how we want the pictures, I'm sure that when you want to fix it, they took the picture of the end of the windshield.
So it could be 20 years.
No. The max, 10 years is the maximum that if you mess up before. But it's how they say. Some people, for this kind of crime, some people just get 2 months. Some people don't even go to jail. Depends on your. This when you get charged, there's always the maximum penalty that you get. The maximum penalty. But charges.
That's why that's what they got. But if you can just bring down one charge, they don't have no proof.
So what?
Yeah, probably how many seems.
Yeah, we're gonna get back down to the third floor.
Oh, Haley, I need you to sign the.
Oh, yes, yes, I can.
I'm just trying to catch up.
Me too, Marcy. I'm just trying to survive at this point.
You're like, I can't wait for next week to be over.
I can, but I can't, you know? I really enjoy being here and like doing stuff and being hands-on.
We're taking bets, you know, on if you actually are gonna come back.
You think?
Mm-hmm.
Like to this court?
Well, just, you know, when you're home with the
I'm
little
gonna come back.
one.
I'm gonna come back. If anybody stays home, it's my husband. I'm sure. I could not. I will be back. I don't know if they'll keep me here. That I would like them to. But I have been here since October, so by the time I come back, it'll be September. They might switch it up. I'm not sure. So yeah, if I were you, I would put.
Well, this
I'd
isn't
put
good.
your
We've got a
money
big
on
old
them.
line down our,
Oh no.
did that just happen? Has it been doing that all day?
No.
No.
It's the first time it's done that.
Okay, that's not good.
Could
Of
be a-
course, when I do it.
Of course, when you do it, it could be the toner.
I think that
I
is
can
what
replace, do
usually
you
does
need these
that.
2 files still?
Yes, I need those.
Okay, then I'm gonna run these ones.
Actually, can I do it? Because I need to look at something. I think I forgot to do something, so I need to look at all of them.
These 2 are hot boxes.
I'll take care of them. I
Okay.
just,
Okay,
okay.
those 2 are hot box.
Let's see, why is
Yeah,
it?
those are just the Germans resets. Guy in the brown shirt was a bit crazy.
Yeah, I don't even know who that guy is.
That's the one I was said that was on the phone.
Yeah, he's the defendant's friend or something.
Yeah, he's the
Yeah.
friend.
He wanted to come charging in after the exam was over.
Well, I thought that's why you left, because I was like,
I did, I
And
want
he was
security.
flipping off
I want
the
security to get him
victim.
out of the building before the victim left the building.
ah,
So he's in the hallway throwing F-bombs at me. I mean, it was right. But I caught him peeking through the shades while testing was going
Yeah.
on. That's when I told him to go down the hallway and sit down somewhere. Peeking in the court.
Right.
Then they closed the shades and that really pissed him off. This reminds me of somebody with his ear to the keyholes here. to listen to the
Yeah.
conversation.
okay, now I have,
I'm locking you in, Marcy.
that's fine,
I'll
thank
see
you.
too.
All right, this is not. I report this. One more thing.
All
I'm
right.
not really having lunch today, I don't think. Let's see.
Well, tomorrow should be easy going. It's just PCCs. You guys don't have a crazy afternoon, I don't think.
No, but neither one of us can really remember what this afternoon is about.
Oh, this afternoon. I meant tomorrow. I was like, you could
Oh.
look forward to tomorrow being chill.
Well, we get to tour the new place.
Oh, really?
Yeah,
That'll be
and I
great.
haven't seen it yet, so.
Yeah. That's exciting. But anyway, I am way too impatient of an individual to stay home, I think. Well, my husband, on the other hand, he's a teacher, he's very patient, but
I apologize for the first. The amount of stuff on the first. The docket is pretty big, or I have a stack of files. Really
yeah,
long.
we'll get through it. There's no jury trials or anything, so
Yeah,
we'll pump it
that's
through.
true. So I just feel bad. Said Jeff, you're not gonna wanna
No.
come back.
Okay, have a good day. I'll see you tomorrow.
Bye.
I'm Darwin on behalf of FNPS Real Estate Group. And I have representing from SNPS, City. Right? Yeah, give you a notice here as we send it. Oh, the first date on Tuesday, April 3rd. I'm directly to my name. That is correct. The 4,900 was paid. It wasn't the rest of the amount, and then the monthly grant after that was not. Right, when I paid $4,900 to my landlord, I, wasn't completely aware in the agreement that it was not. That's normally due on the 16th of every month, was also due on the 6th. I made the 4,900 payment at the time, and I requested from the landlord that, if he could wait until the 16th, at least for the regular rent payment, and I was obviously going to do that. And, he didn't seem too keen on the idea, but he told me to seek additional, resources at that point. So that's been, I'm so pursuing, my ability to do it now. So I've been able to, keep on, keep that physical out, stop, keep that. No, and only because with the court, the language on one of these documents, with, I think the writ, not the writ, it's one of the documents wants to pay the 1265 or whatever is owed at the time. But they won't accept partial payments if they're converted and they're also said that if I were to pay, it also doesn't bar the landlord from using, the writ that was already filed against me. Right away. So I've been trying to get their agreement, and I stipulated order to clear the ground, and I've had a text today to clear the ground, but this is at the step time of May, that I have the rest here, and like, 3,000 something, 3,655. 3,665 is the total for, the rest of the balance that was owed for the April rent, the rest of the balance from tuition dismissal, and then also May. So that would bring me all the current. Thank you. Yeah, so I've been trying to get their agreement that they wouldn't use the writ against me, and we've gone back and forth, but I'm trying to reinstate a new conditional dismissal. that would just pretty much give them, like a no notice mechanism for any future dispute or default, since then towards the end of the lease. And that's, something that I would do not appeal, and so they, decided just, here's that, I guess. Okay. Okay. Thank you. Can I interrupt? I do believe that the order is signed. There's an order of eviction that was signed on April, order of eviction, on April 22nd of 2026. It's the second part of the request for the entry, and then the second part is the order of eviction. It is signed. Yeah, it's actually right into my. Or, I mean, I'll have that on the list. Now, once I create this, wasn't that pretty much, end the case before this, and I guess this last hearing for. Yeah, can I be first? We have tried to work with, the defendant. From what I see, we do have a valid threat. He did fall, and we really want to move forward with the eviction. I mean, we actually set it aside. I mean, I really want to deal with that motion. I don't really see that we have grounds to just policy set aside. The order that I see is signed. In my head, I think that it's valid. So we are actually asking my client, I want the motion to deny his order to set aside.
Accepted $5,000. And this is the case where there was no supplemental complaint. Fine. Possession of. You took the money. If you wanted him out, you shouldn't have taken the money. $4,900. Not the money, and then took the money as if you had money judgment. And so, and he needed at that time only another $1,200 current. Since the filing of that, Brent has approved again. And if I was in this position, I would have to do this. I don't know if you guys are gonna take me out after I just give you all of this money. Which is almost if we take the $4,900 that he paid from $3,000 in pay. We're talking about over $8,000 if you are property, and then he's got to go find another place. And so, no, that was unfair. He didn't call for a money judgment. So I'm going to go pay down to zero. But he had the money when he filed the motion. A motion to say the eviction. He had the money he did. At least that's what he was doing. He just was not unless he got some assurance that he would not be then evicted after that month was accepted. I made a good decision with that because it sounds like what you and your client. But they let it go.
No, if the money was on time, we were gonna, we're all paid what we did, and we essentially money because we think we're gonna end up getting 2 months anyway.
Yeah, he looks like he misunderstood the language actually written in the conditional dismissal. That he was supposed to pay the 4,900 plus an additional month's rent. And that rent should have been a little myself. So I understand where you're protected from confusion, but it's also been a good faith effort on his part for him to come up with this money. He's been in communication with your client, and your client is represented here. Go and find some other, ways to help, come up with the rest of the money. I'm not expecting you to money your way to get out. That wasn't the communication.
And we did communicate, John, and we did communicate, and if you look, that was, he falls on the sixth. We waited for the 22nd because we waited extra time so we could get the money. We weren't in communication. It didn't happen. We set the default, we put the default in, and then he said, well, I got this much. And then if 2 more money came, it was the day before, there was going to be another 1,000 paid. Plus, this is all money that he owes for already living in the summer.
But that's the whole point of the, you agree, that's the whole point of the condition. And he agreed that he's gonna pay $4,900 for moving forward.
And he didn't do that. He didn't take anything since that 4,900. We gave him an extra 2 weeks after that to try to get it together. Still didn't get it. Right before the end of the month, when it was going to increase again, I asked him if he had everything, and he still didn't tell me that he had the full amount yet. And then last time when he came in to try to agree with it, I thought we were under some type of understanding, but then when we left, he came to us with different things that we did not agree upon, and now we're actually worried about photos and all this, and we just want to stop it now. Because
I don't know what you're worried about. I don't know what that means, but that's a lot.
What is that one, is it in order that it is today? I read a check from a third party, just in the original conditions. Also, I do want to say one last thing about this. That condition was drafted by him and his attorney. They were very clean that they report on. It was very drafted. It was all of them. We're just trying to report that. I'm just putting that out there. We misunderstand, and that was his attorney. We agreed to it as written. His attorney drafted it. They drafted it. Now, my attorney is not representing.
Yeah, thank you. And you can start. So, yeah, one way or the other. That's totally. So I will go on the list at this time. And then every day, as he is just get David outside. You gotta pay.
Thank you.
Do you have exhibits?
I sent them to the, I gave them to the judge last time. I was here.
We need to go through and actually mark them. Here. Oh, no, you are. Okay, like, you're in the wrong seat. You sit on the side.
No.
Okay. Let me get my stickers. Are these all number 4?
Supposed to be the conversations. That's perfect.
That looks like the entire thing.
Yeah, that's what the conversations. That was the fifth of attempted release termination. This is. Ledger. Pet payments.
I'm just concerned because he's written 7 on them.
So there's 2.
I don't know.
I have 2
This is
here
all we have.
as proof of that. That's the conversation.
There's a lot of 4s. So do all the 4s go together? They
No.
look like, do I forget it?
Yeah, 4 is a. Like, sorry, I didn't know.
So let's put all those together.
This one like that. 4. Oh, okay. So then that's 4.
These are all. Oh, that's. Here's 3, here's 7. What is this one? And those
Deposit returns. So
We had that right there. Had some conversations with one. And then I guess we do payments for two. Because I don't already have. That's what I'm saying. I don't know what he has for number two. I don't see anything here. Written. It's number two.
I don't see a. And 6 is this.
That's what I said. No, this was two. This is what I had in my line of proof of payments. So the conversations was one, and then proof of payments would have been two. But I guess he didn't write it on anything. I just have it here, or at the top. So I'm guessing that would be two.
So this is gonna be 2.
And I have these next to it. That's what I don't know how to do that. 2, 3, 4. No, that's what I said. I don't know how we got this at number 7, because this was next in my
Oh,
line.
this says number 2.
So maybe that should be 3. Because that would have been in my lineup. I already had it lined up. After payment, it would have been proof of early use termination. And that was 3. And then these are housing denials. So maybe he gave them a different number. But those are all here.
So this is supposed to be what then?
With what? Those are supposed to be for the early lease termination and denial of housing. That's what that was.
Is there anything else this code might go with?
They already have them stapled together. This is this page. Denial of leaving early. That's what this is. This is proof that I had a place to say, but I couldn't move because of that. So that was that page. That's what I had.
Concerned because that has an actual sticker on it.
So we
that
just have
meant-
to do them different. They have to be just done a different order. We go by the stickers than what I actually have.
And I think that is what happened, but now. You let me know that we're just, you're talking. Okay. So 2, 3, 4. So this is okay. We're gonna make this back. Just 'cause no other ones had it. What would this one go with?
We have to look this up. So. This is just saying the return of security deposit.
And 6 is this.
I gave him the hotel receipts. Are those in this file?
I think so.
Okay, yeah. Okay. So that is.
So do we have just 6 then, not 7? Is this yours then, or?
I can just keep that because I didn't put that one, but I can keep it.
You're not wanting to put it with any of these? Okay.
No, that's fine. I don't-
So we've just redid them from what we did before, and he said he's okay with that.
Okay, that's fine. So I just want to write them down here.
Yeah. Is your text messages, I guess? Or no, I guess there's other stuff. Oh, ledger.
Yeah, that's just between the text, yeah.
So that's 1. And 2 is.
Payments.
Oh, here's.
And 3, is, with denial.
It's. All right, you guys ready?
Yeah.
All right. I'm gonna go. All rise.
You be seated. All right, so we're on the record in docket 25-01492. That is Kira Wilkie versus Todd Dowrick. Appearances for the record. And ma'am, you are Kira Wilkie, is that correct?
Yes, that is.
Right, thank you. And sir, you are Todd Dowrick, is that correct? All right. This time set for a bench trial in the matter. We've had some exhibits marked. I think I understand the opening statement wise of the nature of the cause of action in this matter. And this isn't the first time we've had this. We've been here August 5th, December 4th, December 12th, March 31st. We adjourned it to this hearing because I believe we had a jury trial scheduled on that date, and then the jury trial went, and then everything got adjourned. So this was one of many cases on that day that got moved to today's date. This is the plaintiff's case. So Ms. Wilkie, when you're ready.
Beginning after May, Todd repeatedly interfered with my peaceful position.
All right, so you don't have to go through, did you want to testify today?
Yeah.
All right.
Your Honor, if I may, at our last court date, Ms. Wilkie testified, she presented her evidence.
Right.
And then I was supposed to present my evidence today.
Right.
She did all her part.
Right, and I have, the testimony I have includes six, you've had 5 exhibits marked.
6.
Okay, the plaintiff's exhibit is number 6. That's the one I reviewed. And then you've had 5 exhibits marked that were marked on the front. And that's these 5 exhibits.
Yep, and then the 6th one was the drive.
Okay, and the 6th one was the drive.
Mhm.
All right. All right. And have any of these been admitted before?
Yeah, just that the previous court date.
All right. So the exhibit 6 has 1 through 5 still needs to be, admitted, or they've been admitted?
They all have been admitted.
Okay, and have you had the opportunity to see these?
Yeah.
Okay. All right. So for the record, 1 through 6 are admitted into evidence.
Correct.
And then do you have any further proofs today, Miss Wilkie?
No, I do not.
All right. So Mr. Dowrick, I think we adjourned for your case.
For my, yes.
Yes. All right.
my-
So do you have any proofs today?
Yes, I have several things. Do you want them marked?
Yes, they'll need to be marked if there's a motion to admit, and Miss Wilkie will have to have been seen by Miss Wilkie.
They were all mailed to her.
Okay.
'Cause I was instructed to mail to her. She was instructed to mail to me. I didn't
All
get
right.
anything, but I mailed a big packet.
All right. So what exhibits do you have to mark?
I have 1 through 11. Now I wrote 1 through 11 on the first page of each exhibit. If
Okay.
that suffices.
We'll have them remarked for our purposes.
Okay.
So just refer to them as you're going through them.
Okay.
And then make sure that they were married to Miss Wilkie, so she had discovery, and then we'll mark them as we go.
Okay.
Okay. So yes,
Are they gonna be numbers or letters?
they'll most likely be letters if we use numbers for her. All right, and if you're going to testify to them,
Yeah.
let's go ahead and swear you in. So your name is Todd Dowrick.
Yes, sir.
And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth on a penalty of perjury?
I do.
All right. All right, Mr. Dowrick, and then I'll field any questions later for cross-examination purposes. Mr. Dowrick, you may proceed.
Okay. My first piece of evidence is my answer to the case. Would you like?
I don't. I think that's a part of the record, your
That's part
answer,
of-
and I read it this morning.
Okay,
Yeah.
good.
I reread it this morning. I read it previously.
Okay. So in my answer, I said, Miss Wilkie turned in a 30-day notice and moved out at the end of her lease. No harassment, no violation of Michigan law. Number two, did not knowingly and intentionally misuse the eviction process. Absolutely not. Number three, the property was habitable, inspected by MISHDA Section 8 prior to moving in. Maintenance requests were completed timely. We treated the building for roaches on September 14th of 2023. The house was inspected by MISHDA and the city of Lansing, providing a certificate of compliance for rental dwelling. Every rental property has to be inspected by Section 8 before a tenant can move in. It's got to be in perfect shape. It passed the inspection, and the following day, we were able to start the lease, which was September 13th of 2023. Miss Wilkie submitted a 30-day notice to vacate, and she moved out on September 30th, 2024. She was not evicted and was welcome to continue living at the property.
Right, and that's a part of the answer to the complaint.
Yes.
Okay.
And then my second piece of evidence is the lease.
Okay. And that, I think, we'll go ahead and mark that. We'll mark that as, but I think the lease has also been as part of the complaint, but we'll mark that. So we'll mark that as Defense Exhibit A. And you may proceed, Mr. Dowrick.
The lease was signed on August 18th of 2023. It was signed by me and Miss Wilkie. For the property at 3413 Wainwright. The lease began on September 13th, 2023, and expired on September 30th, 2024. Miss Wilkie paid a $800 security deposit. Her signature is on the back of the lease. She signed on August 18th of 23. I signed on August 24th of 23.
And that's a lease that runs 1 year?
That's the lease that runs 1 year, and she moved out at the end of that lease.
All right. Do you have any objection to the court admitting that'd be Defense Exhibit 1, which is the lease?
Yes, I do.
Okay, and what's your objection to the lease?
That he breached the contract, so that's why I left.
All right, but you don't, the lease itself, there's nothing wrong with the lease. You signed the back of this?
Yes, I did.
That's your signature?
Yes,
All right.
yes.
I'm going to admit the Defense Exhibit A. Defense Exhibit A as the lease. And you may proceed, Mr. Dowrick.
My second piece of evidence is the residential lease addendum, number B, letter B.
All right, you may proceed.
Couple highlights from the residential lease addendum. No appliances were provided. Number 8, we always have the tenant initial that. If they have maintenance requests, they put them in writing. At the presentation of Miss Wilkie's evidence, it was noted by the court that maintenance issues were not part of the suit. That was not an issue with the suit. There was 5 people to reside in the premises. Miss Wilkie paid a $400, that's number 12 on the backside. Miss Wilkie paid a non-refundable cleaning fee in the amount of $400. to cover cleaning expenses upon move out. So that is B.
All right. Any objection to the defense exhibit B being admitted, which is the residential lease addendum that was just testified to by Mr. Dowrick? Any objection, Ms. Wilkie?
Yes, because the home was clean and he charged a $400 non-refundable.
So your objection to this is not to the lease, it's to what the lease represents.
That's a part of the lease. He's
Okay.
saying that's the $400 cleaning fee.
The exhibit B is admitted into evidence. You signed the back of this, ma'am?
Yes.
All right, thank you. All right, so that's defense exhibit B. And you may proceed, Mr. Dowrick.
Exhibit C is the inventory checklist. This is signed by me and Miss Wilkie. And of course, Section 8 inspects the property the day before she can move in, so it's got to be perfect. But this is the inventory checklist in addition to that.
All right, and this is signed at the bottom by Miss Wilkie.
Yes.
All right. Any objection to the inventory checklist being admitted, defense exhibit C? And you did sign the bottom of that, ma'am.
Yes, I did prior to moving.
Okay. All right, so with that understanding, your indication is you signed it prior to move in. We'll admit defense exhibit C. And you may proceed.
The next piece of evidence remarks D is in David. And this comes from the MISHDA Section 8 office. The lease, like the written lease that I presented with A, shows that the residency began on September 13th, 2023, and ended September 30th or November 30th, 2023. So the property was inspected by Section 8 on September 12th, and then we're permitted to start the lease the day after the inspection. So that's when the lease began.
All right, any objection to the MISHDA housing choice voucher adjustment notification being admitted to evidence? That would be exhibit D, Miss Wilkie.
What did you say was the November date? What was that for? What did you say about November?
This amounts are identified below beginning September 13th, 2023 and ending November 30th, 2023.
Oh, okay, yes.
That's the nature of the exhibit. And then contract rent is $1,200. And it's signed by Mr. Dowrick by the MSHDA agent. And I can't read that. Oh, look, that is Miss Gibson. And then she printed her name underneath. Any objection to that being moved into evidence, Miss Wilkie?
No.
Hey, without objection, exhibit D is admitted into evidence.
So again, Your Honor, the lease began on September 13th of 23, and then the lease ended September 30th of 24. And that's when Ms. Wilkie moved out. My next piece of evidence, E, is the 30-day notice, actually two of them.
That might be a part of the court record, but we'll admit it. And that would be exhibit E.
E, I believe.
All right, you may proceed, Mr. Dowrick.
So I actually received two 30-day notices from Miss Wilkie. The first sheet says, this is on August 29th to 24. Todd Dowrick, I am writing to provide you with the required 30-day notice. I will be vacating the property located at 3413 Wainwright by October 1st. I will return the keys to Marcelo. So this is the email sent to me from Miss Wilkie, giving me her notice that she's moving out. So she moved out the last day of her lease, or maybe one day after. She gave a notice and moved out.
All right, so this is email sent from Miss Wilkie to you, and then Miss Wilkie signed the back of the 30-day notice to vacate, which is which you returned to the Housing Commission.
The second 30-day notice I received with the back sheet, this was turned into the Section 8 office that she was moving out October 1st of 24. She signed it September 1st of 24.
Right, any objection to motion to admit Defense Exhibit E? It looks like an email that you sent, and then you signed the second 30-day notice. Any objection, Ms. Wilkie?
No.
All right, without objection, Exhibit E is admitted into evidence.
The next piece of evidence is the certificate of compliance for rental dwelling from the city of Lansing.
And that would be Exhibit F. All right, you may proceed, Mr. Dower.
The property in question 3413 was not only inspected by Section 8 prior to the tenant moving in, it's also a licensed rental property that gets inspected every 2 or 3 years by the city of Lansing. The current certificate is good through September 1st of 27.
And that's the Wainwright Avenue address.
Yes, yes, sir.
All right. This may be a part of the, well, I don't know. It is a part of the economic development planning, the notice for certificate of compliance. Any objection to the admission of Exhibit F, Ms. Wilkie?
No.
Okay, and Exhibit F is admitted in evidence.
My next piece of evidence is the verification of good standing that I completed.
So that would be G. Right, you may proceed, Mr. Dowrick.
I received this form from the Mishta Section 8 office, and I signed it on September 11, 2024, stating that Miss Wilkie is in a tenant in good standing as described above. Now, I probably shouldn't have, because there was still a balance due of the rent, but I did complete that and submit that to Section 8.
All right. So, all right. So so Section 8 received a good standing below on September 11th in Exhibit G.
Yes, I completed that on behalf of Miss Wilkie. So for any prospective landlords, or letting Section 8 know that she was in good standing at that point.
All right. All right, any further evidence, Mr. Dowrick?
Yes, sir. H is a security deposit notice to tenant.
Thank you. This is a notice provided to the tenant. You may proceed on Exhibit H.
Thank you. The I want to note I have highlighted on the upper right that the new address was received by me, the landlord, on October 28th of 24. So I received it late. I didn't receive it within the 10 days, but I still proceeded with it and processed it and submitted the form to her. And I don't believe there was any complaints about that, but Miss Wilkie provided that late to me. I still proceeded. And she got most of her security deposit back.
Yeah, a pay to the order. I have a check made to the order of Kira Wilkie for $680.
Yes. So there were two charges, of which I have pictures for the charges here. Number one, a red marker written on a bedroom door, $50. A hole in the wall of the bedroom, $70. So that totals $120. Her deposit was $800, and she got the check for $680.
All right, any objection to the court admitting Exhibit H into evidence of Miss Wilkie?
Yes, the security deposit was $1,200.
All right. All right, so there's some dispute concerning the exhibit, but that'll be worked out during testimony and facts of the case. I'm going to admit People's Defense Exhibit H. And you may proceed, Mr. Dowrick.
Exhibit I are the pictures of the damages. It includes the hole in the wall, the red marker on the door. And I have a collection of things within this exhibit. I have the receipt for where I paid $120 to have these items repaired. And I have the receipt where I paid for the non-refundable cleaning fee. Again, the security deposit was $800. It was a $400 non-refundable cleaning fee. So I have these receipts. I guess I also have with this, when I received that notice with the new address on 10/28 of 24. So this would be Exhibit I. I only copied that.
All right. So we'll have that marked. We'll have that packet marked as Exhibit I. All right, so Exhibit I is the photographs concerning some of the damage, a receipt concerning some of the damage. And then it looks like an indication that the tenant's moving out on Monday, September 30. I can't meet at the time. Just leave the keys in the mailbox. That was your understanding of the email, was to indicate that she couldn't meet at the time, and she was just going to leave the keys in the mailbox.
Yes, what I wanted the court to see is there were two minor repairs. The repairs were completed. I paid for the repairs. I paid for the cleaning, all part of the lease. I did not have an objection to the $120 in security deposit at the time.
All right. Any objection to the defendant's Exhibit I being admitted to evidence of Ms. Wilkie?
Yes.
Okay, state those for the record.
He did not provide the before move-in photos, actual receipts for the material, the labor costs. He sent in a handwritten receipt. And he needs to be able to prove that this damage actually happened during my tenancy. It was not pre-existing. The cost is accurate. The repairs were actually performed and money was actually spent.
All right, with your objection noted, defendant Exhibit number I is admitted into evidence. Mr. Dowrick doesn't have to prove anything in this case. He's the responding party. So you have to prove all your allegations. That's kind of how it works. So you being the plaintiff, the moving party. So I'm going to admit Exhibit I. There's some dispute as to some of the indication concerning the receipts, and I have October 3rd. These are both dated October 3rd, 2024 as evidence of the damages. I'm assuming that that's part of the authentication, is that you're saying these were both taken on October 3rd, 2024.
Yes.
All right. All right. Exhibits I is admitted into evidence.
Exhibit J is the ledger.
And you may proceed, Mr. Dowrick. We're on Exhibit J.
This is the ledger for the duration of Miss Wilkie's lease. She didn't always pay her rent on time. Sometimes she did, sometimes she didn't. We did have a court case that I ended up dismissing.
What's the date of that dismissal?
Of that court case?
Yeah.
It was dismissed on October 8th of 24.
All right, you may proceed.
In hindsight, I shouldn't have dismissed that because there was a balance owed. A lot of it was late fees. The last rent payment for September was not made. So looking at the ledger, it shows, and I reviewed this very, very closely. The lease began on September 13th of 23. Section 8 paid all the rent for September, October, November of 23. Now we come to December of 23, and now Ms. Wilkie has a copay. Now all her rent is not paid by Section 8. So in the month of December, she did not make a payment. She did make a payment in January that left a balance of $60. If the court could notice that under January of 24, the balance $60 by the date 1/1/24. So there's the first month of December when rent wasn't paid. January, rent was paid fine. I have a 4-day grace period. February, everything was fine. March, everything was fine. April, I did not receive a rent payment from Miss Wilkie.
And what was her rent payment at the time?
$363.
$63. All right, that was a portion of the rent payment. And then what was the full rent?
Her full rent was $1,200.
Okay.
Section 8 was paying $837.
Okay.
So that's April. Now we get into May. And May was paid on May 7th, which is late. If it's received by the 4th, I consider it good. $363 was paid on May 7th, leaving a balance of $518. Now in June, there was, these payments were coming in all different ways. And there was a payment that Miss Wilkie had made for $370, but I didn't have it. The bookkeeping didn't have it recorded. I asked her for a few months to provide me, as I always do if a money order is missing or not accounted for, the front and back of the money order. It'll show that she purchased a money order, and the back will have my signature on it that was signed. So there was an issue with a $370 payment which you see the highlight, June 3rd payment was not recorded initially. June late fee of $70 was waived. But that still left, even with that payment, that still left a balance of $511 for the month of June. Then we get into July. Ms. Wilkie made a payment, but didn't pay off the back balance.
The rent was according to the ledger, that 511 was still outstanding, and then it continued to be in July.
Yes, sir. So end of July, there's still 581 owed. August, we have the back rent of 581, the rent of $1,200. Because she wasn't paying off the back balance, a late fee. So there was a money order that was paid at court. That was the 363 dated 8/28. That was paid at court. So that left 288. Then we get into her last month, the month of September. She had the balance of 288, the rent of 1,200. Judge Buchanan allows a late fee of 40, so that was set at 40. Section 8 paid 837, leaving a balance of 691. So I did not file a counter complaint in this court case asking for this 691. Maybe I should have. I did not.
And then there was no September rent paid. Of 2024?
Yes. No, none by her. None by her.
All right.
Right.
All right.
So,
Any objection to the ledger coming in? Motion to admit the ledger, Ms. Wilkie.
Yes,
And you can
I
state
do.
your objections for the record.
I owe him no rent.
All right.
And he did get paid for September. He got paid for September when we went to court on August 28th of 2024. When he was claiming that I did not pay June rent, that I had to come and show proof that I did pay June.
So the exhibit J is in dispute, but I'll admit it into evidence. Defense exhibit J.
again, Your Honor, I didn't file a complaint to sue for the 691. I let it go. In hindsight, I probably shouldn't have dismissed the case, the court case. You know, some of these are late fees, but nothing, I have got nothing. The rent paid on August 28th was for August. So I'm not worried about the 691. I guess the main point I'm trying to make with the ledger is the rent was not paid consistently on time. There were issues with the rent throughout the lease beginning in December of 23.
All right. Any further exhibits, Mr. Dowrick? We have A through J.
I guess the last one would be my discovery request.
Okay.
Which I submitted.
And I think that's part of the pleadings, but we'll mark it.
Okay.
And that'll be exhibit A. And you may proceed, Mr. Dowrick.
Number 1 says the entire house, basement, and garage were cleaned. Receipt enclosed. I already submitted that receipt for the cleaning fee. Again, it's a non-refundable cleaning fee. I've never had to disclose anything about that. It's initialed by her. It's a non-refundable cleaning fee, but I provided the receipt that I did pay for that to be cleaned.
Right. Any objection to K being admitted? I think it's a part of the discovery request, but K being admitted, Ms. Wilkie.
Yes,
And
evidence 6 of my video shows the opposite.
All right, so there's indicating that K is in dispute. And I will admit Exhibit K at this time. Anything else, Mr. Dowrick?
Just briefly,
Okay.
number 2 and 3 is the receipts for the 2 repairs that were done and the pictures of the repairs that were done. And 4 is just a summary of the ledger that I submitted with this. The tenant owed $691. Payments were not made some months, including September of 24, the last month of tenancy. Rent was received late some months. No rent payments were made by the tenant in December of 23, April of 24, or September of 24.
All right, any further evidence today, Mr. Dowrick?
No, I guess the last thing I want to mention, there was a payment I testified that was not recorded. I had asked Miss Wilkie several times to provide proof of that. Eventually she did once she had the legal aid lawyer, and then she was given credit for that. She received a satisfactory status with Section 8. So nothing further, Your Honor.
All right, so that's not on the ledger. Was that done by Section 8?
What was that now?
The credit.
That was me giving her credit.
Okay.
It's the highlighted one on the bottom of the first page of the ledger.
So it's in June?
June
of 2023.
Yeah, payment was not recorded initially.
Okay.
And that's where the June 3rd payment, and that's the line right above where she got credit for the $370.
All right, Ms. Wilkie, you can address any questions to me, and I'll see if Mr. Dowrick can answer the questions. If you're going to make a statement, you'll get plenty of time to make that statement. I've admitted your exhibits of 1 through 6, and I've admitted, let's see, 1, 2, 3, 4, 5, and 6. And I have had the opportunity to see exhibit 6. And then I've seen, and then Mr. Dowrick just moved for the admission of A through K. Do you have any questions of Mr. Dowrick, Ms. Wilkie?
Yes. Do you know what it means to disturb a tenant's quiet enjoyment?
I don't know. I don't know if that's a question. So that sounds like, do you know what it means? Is there a way you can rephrase that question so that sounds like badgering?
Do you understand that tenants are entitled to a peaceful possession of their home?
Do you understand that the tenants are part of the lease indicates that they'll have a peaceful enjoyment of their home?
I certainly do, but when rent's not paid and according to schedule, you're going to be contacted by our office. All
right, that's your answer, Ms. Wilkie.
Okay. Do you know that repeatedly making false claims of non-payment and bringing a tenant back to court can disturb their quiet enjoyment?
That's an assumption. It's built into the question that these are false claims.
And it wasn't a false claim. We went over the ledger. Money was technically still due. I didn't sue for it. Rent was not paid on time. It was an issue throughout the tenancy.
All right. Question.
Would you agree that repeatedly making false claims of non-payment could affect a tenant's housing?
So once again, it's built in the question is this essence of false claims. So you may answer that question.
There was several payments that were not made on time, some that weren't made at all. That's all very true. There was one missing payment that somehow didn't get recorded. I asked for the front and back of that money order receipt. Very rarely do we miss one. In this case, we missed a payment for $370. Once that was finally provided to me, Ms. Wilkie received credit for it.
Further questions, Ms. Wilkie?
Are you aware that filing a false eviction case keeps a tenant from moving where they prefer because the case shows up on background checks?
Once again, built into the question is this nature of, that this is something fraudulent was done.
It wasn't false. Rent was owed. Even beyond that $370, rent was owed.
Next question, Ms. Wilkie.
Knowing what you know now, that the months you accuse me of not paying were paid, do you accept that your conduct made it impossible for me to feel safe staying in that home?
The exact opposite. I feel you are hostile toward me on several occasions. Very difficult. I asked you repeatedly if you thought you made a payment. We don't have it recorded. I've said this already. Get us that canceled money order receipt, and that's the proof.
Thank you, Mr. Dowrick. Any further questions, Ms. Wilkie?
Did you take me to court the first time in August of 2024 over April 2024 rent?
August of 2024.
For the payment for April of 2024.
When was that complaint filed, that first complaint?
It was filed on June 13th of 24.
So that would be the first pretrial date, I would assume.
I believe the first pretrial date was July 31st of 24.
All right. And that was for non-payment.
And that was for non-payment. Again, rent was still owed beyond that. Once you got credit for that $370, rent was still owed.
And is that the case that ended up in dismissal?
And this is a case that I dismissed and shouldn't have, in hindsight, on October 8th of 24. I dismissed the case. Ms. Wilkie was represented by Billy DeShawn.
All right. Further questions, Ms. Wilkie?
Did you bring me back to court a second time in August 2024 over the June 2024 rent payment?
I would assume that's part of the pre-trial process or the formal hearing process. So the answer is yes, but once the complaint's been filed, then the court takes over and sets the hearing schedule as far as the formal hearings and the pre-trials. So the answer to your question is kind of yes, because he's filed the initial complaint, but then the court takes over.
Okay. Did I have to appear in court again on September 10th of 2024?
I would assume the answer is yes. If she's being sued at that time, and this is part of a non-payment case, then she has to come to court to answer the complaint filed.
I know we did the dismissal. This is dated October 8th.
October 8th.
And looks like we had a.
So in August, she probably did have to come to court.
I think, yes. Initially, we had a hearing date. Looks like it was August 28th.
Okay.
But then that was adjourned, I believe, until October when Ms. DeShawn got involved with the case.
All right. So the answer to that's kind of a yes, kind of, because once the court gets involved, then we start having hearings.
Okay, was there yet another hearing scheduled for October 8th, 2024, this time over the August 2024 rent payment?
It was all the same thing. It's all the same case, dismissed on October 8th of 24.
And on that same date, October 8th, 2024, after I had a free public attorney named Billy review the evidence with you, you text me, I dismissed the court case as per proof of payment. Apologies for missing the payment, correct?
Yes, I missed that 300. We missed, the office missed that $370 payment.
All right.
When you dismissed that final case, did you dismiss it with prejudice?
I don't know what prejudice means. Prejudice?
Yeah, prejudice.
Dismiss it with prejudice? Yeah, I don't think they're usually dismissed with prejudice. I think I think the court has to sign the order. But
well, prejudice, it says Prejudice means that dismissal is a final, and you cannot refile for the same claim. So when he says that he could have countersued, technically it's saying that you can't do that.
Only I can sign the order that dismisses with or without prejudice. That's generally how it works, but I don't know what I signed and I don't know what I signed on this date.
I think this case was before Judge Buchanan.
Okay.
Are you aware that an eviction filing appears on a tenant's public record?
I'm not sure if it does, if it's dismissed. But again, money was owed.
Are you aware that I was denied housing by First Choice Real Estate on September 4th because of your eviction filing?
I have no idea what you did. All I do know is I signed a satisfaction.
I believe that's part of your exhibits, is it not?
I signed the verification of good standing, saying to Section 8 that everything was okay.
Are you aware my family stayed in hotels from September 30th, 2024 through March 15th, 2025?
No, I am not aware that you stayed in a hotel. However, your lease was up. You could have renewed. We would have still renewed it. You gave 2 30-day notices to move, and you choose to move out of the house. So as far as I'm concerned, you could still be living there. We didn't ask you to leave.
Do you accept any responsibility for that situation, given the case you filed and then dismissed yourself?
No, because you owed rent beyond that $370. And if you provided the proof that I asked for a few months prior, it would have been recorded.
Did you verify your bank records before claiming I did not pay April rent?
I don't have individual bank records. When I make a deposit, it's a big collective deposit. I can't see Kira Wilkie's payments. But again, we reviewed the ledger. Rent was owed, and rent was not paid on time, and some months it was not paid at all.
So you filed for eviction without verifying whether rent was actually paid, correct?
The assumption is that you're just going from the ledger and not going into the bank accounts.
What happened was at court, finally, I think Mr. Schoen requested for Kira to get that canceled money order. Finally, she provided that. And at that point, I made the decision to dismiss the case on October 8th of 24, although rent was still owed. And then that last month, I never did receive the payment. Some of it was late fees. Perhaps I'm a little intimidated by a lawyer. I'm not a lawyer. And I made the decision to dismiss the case. But that doesn't mean that rent was not owed and rent was being paid on time consistently.
So you filed for eviction without verifying whether rent was actually paid, correct?
No.
Did you check your bank statements before filing the eviction?
I think I answered that.
I think that was answered.
So you filed legal action without confirming the amount due, correct?
I think that was answered also.
Okay. Are you aware that MCL 657-16 requires the correct amount due to be stated before filing a demand for commitment?
What is MCL 600? Quote that for me.
Those are when you,
Let's see that. Show me a copy of that statute. You can provide it to my court officer. Okay, so that's the MCL you're relying on. And your question is, a demand for possession or payment shall be in writing addressed to the persons in possession and shall give the address or other brief description of the premises. The reason for the demand and the time to take remedial action shall be clearly stated. When non-payment of rent or other sums due under the lease is claimed, the amount due at the time of the demand shall be stated. The demand shall be dated and signed by the person entitled to possession, his attorney or agent. So that's 600-5716. So your question relies on that statute.
Yeah, for it to be
All right.
correct, the amount to be correct.
All right, so go ahead and ask that question in relation to the statute.
So, again, I said, are you aware? Okay, so the correct amount due to be stated before filing a demand of possession, for possession. That's what I'm saying.
All right,
The correct
respond.
amount.
I saw that from the ledger, but I'll let you answer the question.
At the time, I thought we had the correct amount, even with that payment that we gave you credit for when you finally produced it. And again, if you would have produced that as I requested, instead of arguing about it, you would have got credit for it. So, rent was still owed and is still owed beyond that amount that was filed for. But I dismissed the case. I made that decision.
No rent is owed. And I explained to you.
You'll have all your chances to talk, so you can just ask the question.
Okay, so who is responsible for maintaining the rental accounting records for my tenancy?
Our office.
So you were responsible for ensuring that the records were accurate, correct?
We do our best. We do our best. Money trickles in from many, many different sources. Lots of times not on time, like your payments, sometimes not at all. But we do our best to maintain a whole lot of ledgers.
Okay, so you relied on them to claim I owed rent and to file eviction, correct?
You did owe rent, even considering, I mean, I'm saying the same thing over and over. You did owe rent, even considering the $370 payment, which once again, if you would have provided proof of that as I asked, you would have got credit for it, and eventually you did.
On August 2nd, 2024, did you text me in writing, accounting missed the April payment, received April 3rd, 2024?
I'm not sure, I don't remember.
Okay.
But that sounds like that sounds like you admitted that you missed that payment. You missed the payment.
Oh, that one, yes.
On August 2nd, 2024, did you write to me, I see you made a payment of $363. I have recorded on July 8th. It may have came in late June as I was away for 10 days.
I think that's the same payment, but
I don't know. I mean, I don't, my memory's not perfect. I can't remember. I sent lots and lots of emails out.
Do you recognize Western Union money order that ends in 491 for $363 made payable to Ty Dowd, cleared on April 9th, 2024?
so that's April 9th, 2024.
Mhm.
And the case was dismissed in October. Is that a part of your exhibits?
Yep.
Which exhibit?
It should be in the 2.
Okay. So I have a Western Union from Walmart for $363. A Western Union from Walmart, a Western Union for $736. Money order doesn't say the amount on that one. $408 on that. And then, so so what number you're talking about? We can let Mr. Dowrick explain it.
I'm talking about the April's rent, that payment.
April.
It was paid to him in April.
But what in the amount of?
$363.
$363. So that would be. I have a Walmart signed by at the top of Exhibit 2, that clearing date was April 9th, 2024. Is that the one you're talking about? All right. All right, Mr. Dowrick, she's talking about Exhibit 2. What question do you have concerning Exhibit 2?
Do you recognize Western Money Union made payable to Todd Dowrick and it was cleared on April 9th, 2024?
That was the payment that you were given credit for in the ledger once you finally provided proof of that. It wasn't recorded under April, it was recorded in June. I have 370 down for some reason on June 3rd. But again, you still owed money and you still technically owe $691 through September of 24.
So that is the missing payment.
That must be the missing payment.
Okay, all right.
Do you recognize Western Union money order that ends in 1039 for 370, cleared on June 10th of 2024?
Not off the top of my head, no.
Is that an Exhibit 2?
Yes, that is.
It would be June 10th exhibit for 370. I think that's it.
So you were publicly telling me on June 10th, 2024, you had not received June rent. Were you aware on that date that
But
this money
that sounds
order
like
was
2 or
cleared?
3 questions there. So let's just ask one question at a time.
You were publicly telling me on June 10th, 2024, you had not received June rent. Were you aware on that date this money order had cleared?
On June
10th.
No, I'm not sure of that. I'd have to research that.
The fact that it clears with the bank doesn't mean that Mr. Dowrick knows that it's been cleared.
Well, I would think that you would know that, or you should check your records to know if it was cleared if you're accusing someone of non-payment for that month. You should not just be able to claim.
It sounds like a statement. That sounds like a statement. So you can make that argument, okay? But that doesn't sound like a question.
Do you recognize Case Credit Union check that ends in 451 for 363 dated June 27th, 2024 made payable to you?
No, I don't know all these. I don't know all these.
Talking about,
I get hundreds of them.
This would be a part of Plaintiff's Exhibit 2. It would be the check written to Todd Dowrick from Kiana Wilkie for $363. Is that what you're talking about, ma'am?
Correct.
All right. All right. I have that. I have that exhibit. It's part of Exhibit 2. And you may or may not be aware of that. That's okay.
So USPS records show this was held at East Lansing Post Office at your request from July 1st through July 6th. Did you submit a whole mail request during that period?
I'm sorry.
It sounds like there's evidence in there. So
do you recognize Case Credit Union check that ended in 642 for 363 dated August 1st, 2024?
No, I don't have these memorized. I have the ledger, which went through with a fine tooth comb with a member of my staff, and I believe it's totally accurate. But no, I don't know these money orders and checks. And
okay, so on May 7th, 2024, you text that I owed $518 through May and said no rent was paid in April, correct?
I'm not aware. I'm not for sure.
On June 10th, 2024, did you text me you owe $581 through June? Must file eviction soon and rent for June not paid?
Off the top of my head, no, I don't know either way.
After I sent you USPS proof that June rent was delivered on June 1st, 2024, you stopped claiming June was unpaid and started claiming July was unpaid, correct?
All I know is June rents has to be paid in full on the ledger before July rent. So June has to be paid before July. So I believe the ledger is 100% accurate. I can't tell you the exact, I'd have to research that.
Each time I provided proof. You changed the month. You claimed was unpaid, correct?
Sounds like an argument. That sounds like you're arguing with the witness. He doesn't have to answer that, but if he wants to, the answer to that's going to probably be no.
On August 2nd, 2024, after I sent you the cleared April money order, did you write accounting missed the April payment received April 3rd, 2024?
I don't know exactly what was said. Again, I think the ledger is very accurate. Your rent was not paid on time. Some months it wasn't paid at all.
Under section 17A of the lease, eviction is only allowed if rent is unpaid, correct?
You can evict people for lots of reasons, but again.
Under 17A.
Your rent wasn't up to date.
If rent was paid, eviction would not be allowed under your lease, correct?
For the rent portion, you could evict somebody for selling drugs, over occupying, not paying the rent on time is a legal eviction.
Did you collect a $400 cleaning fee from me at move-in on August 18th, 2023?
We received a $400 non-refundable cleaning fee.
From a cleaning, okay, do you have itemized receipts from a cleaning service, store, or contractor showing actual cleaning costs after I moved out?
Those receipts were provided to the court. I have a witness here to testify that he was responsible for that work.
That's exhibit I.
Yes.
Okay, you also charged me $50 for a red marker pen mark and $70 for a hole in the wall. Do you have dated before and after photographs of those items?
Well, I know that section 8 inspected the property one day before you moved in. I know with section 8, it better be perfect or they're not going to approve it. I know you signed an inventory checklist, but with section 8 approving it, that's golden. That means everything is in really good shape.
Were you aware that I reported the home had no hot water and heating issues?
I don't remember exactly the maintenance request, but I know everything was dealt with promptly. And I know you testified during your part that maintenance issues was not a part of this use.
Well, you brought, it has to be because your witness, isn't he talking about?
That doesn't sound like a question. That just sounds like an argument.
Okay.
So I'm going to give you plenty of time to make your argument, but that doesn't sound like a question.
Okay. Did I send you emails on September 5th, 2025 and October 25th, 2025 requesting specific documents, bank records, receipts, before and after photos, and a correct ledger?
I testified to the court that I don't have individual deposits. I have group deposits that I make. I can't tell when Kira Wilkie when we made a deposit just on one tenant. We make a collection of deposits. I made one yesterday. There's probably about 15 people that money was deposited on behalf of.
On February 12, 2026, did this court order you to provide the documents I have requested?
No, I don't think so. And I can't give what I don't have.
So instead, you sent documents I did not ask for. Text messages with your son, a security deposit notice, handwritten receipts, photos of damages, and my own move-out email.
That sounds like a statement, but if you want to turn that into a question, he can answer the question.
Okay. Okay, I think that's it for now.
All right. So cross-examination is finished with Mr. Dowrick. Mr. Dowrick, do you have any further proofs concerning this matter?
I do have a witness to testify. I Probably keep it very brief, hopefully.
All right, you can call your witness.
Marcelo Oliveras, please.
All right. So, Mr. Is it Oliveras?
Olivares.
Oh, Olivares, all right. You can come up here. Please state and spell your first name and last name for the record.
Marcelo Olivares, Marcelo, last name Oliv as in Victor, Arez.
Okay, please raise your right hand, sir. Do you solemnly swear from tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, you can have a seat. The microphone does not amplify your voice, so please project as best you can. And Mr. Dowrick, when you're ready.
I'm going to keep this pretty brief because I think the evidence was covered pretty clearly. Marcel, I guess first of all, what is your occupation?
Property manager.
Okay, and how long have you been doing that?
February of 22.
Okay.
2022.
And you're familiar with Miss Wilkie and the property on Wainwright?
Yes, I am.
Okay. Did her lease begin on September 13th of 23 and end on September 30th of 24?
Yes, it did.
Did she sign a residential lease addendum
Like right now.
stating that a statement saying there's a $400 non-refundable cleaning fee?
Yes, she did.
Did we force Miss Wilkie to move out of the property?
We did not force her to move out of the property.
Did Miss Wilkie submit 2 different 30-day notices and then move at the end of her lease?
Yes, she did.
So no forced by us?
Not at all, no.
Okay. Regarding the security deposit, were you responsible for the 2 very minor repairs, one being the red marker on the bedroom door, which the picture was provided, the second being the hole in the bedroom door?
Yes, for addressing those, yes.
Okay, and that was a total of $120.
Correct.
I believe that was pretty reasonable.
Yes.
Were you responsible for the cleaning of the house, basement, and garage after Miss Wilkie moved out?
Yes, that's correct.
Was there plenty of work that had to be done?
There was a full non-refundable amount.
Regarding the ledger, have you reviewed this ledger very carefully?
Yes, I have.
Do you believe it to be accurate?
I do believe it to be accurate.
Did Miss Wilkie pay her rent every month?
She did not pay her rent every month.
Did she pay on time every month?
She did not pay on time every month.
No further questions, Your Honor.
All right, Ms. Wilkie, you may ask Mr. Alvarez some questions.
Did I inform you that the kitchen sink was not draining properly when I first moved in?
I'm not aware of anything of that nature. I don't handle maintenance requests.
Did you come to my home without prior notice to serve court papers?
We personally served. There's part of the process of being personally served.
When you came to the property to serve papers, did I tell you that April rent was already paid?
I don't remember.
Did you tell me that you would speak with Todd about the missed payment?
I don't remember the first question, so I definitely don't remember that.
When I moved into 3413 Wainwright, did I inform you that I found a roach in the home?
I don't recall that.
Prior to move-in, did you or Todd inform me that there was a roach issue in the property?
I don't remember any of those conversations.
Okay. That's it.
All right. May this witness be excused from the plaintiff?
Yes, sir.
Sorry, I do have one question, because you said you cleaned. What did you clean? What was dirty exactly in the home when I left?
I've cleaned multiple properties since this date. We have the pictures. It was a pretty standard process, so
So you're unsure what you had to clean then?
I don't recall exactly, but I do remember it having to have myself and 2 other individuals in there to complete the process.
How long would you say that it took you guys to clean, which was stated the garage, the upstairs, the downstairs? How long was that? How long did that
This,
take?
the receipt indicates it happened in October of 2024.
Helps me with the reference, so on that date, but then when it was invoiced.
Okay. That's it. That's it. Okay, no further questions.
All right, may this witness be excused?
Yes.
Okay, you're excused, sir. Thank you for your appearance. Any other proofs today, Mr. Dowrick?
No, sir.
Does the defense rest?
Yes.
All right. I have exhibits admitted 1 through 6, and I've been able to review the exhibits. So we're kind of back in your court, Miss Wilkie. We can go to closing arguments, or you can call rebuttal witness.
Nothing further beyond what I've already said.
All right. So close it. So in your closing, and I have the exhibits in front of me. Go ahead and indicate the nature of your theory of your case, because you're the moving party.
Okay.
I get it that this is what my understanding of the nature of your case. I've got your complaint pulled up. Is that because you were what we call constructive eviction, because you were forced to leave. You're indicating that Mr. Dowrick is responsible for any housing that you had to go through, or any type of hotel that you had to stay at, things of that nature. And you're requesting up to $25,000. Is that correct?
That is correct.
Okay. Anything you want to add to that?
No, because that's basically what it was. I just could no longer stay in the home. It was no longer peaceful. It became hostile, stressful, and unlivable. His actions violated my right to peaceful possession. It breached the lease itself and caused significant emotional, financial, and reputational harm, because even to this day, if I want to go apply somewhere, it still is seen that I had an eviction, a false eviction. He filed a record eviction without cause. He ignored my evidence and refused to allow early lease termination, which caused me to be homeless.
And that's the allegation, and then it was dismissed. Is that correct?
Correct.
All right, Mr. Dowrick, response to the closing argument.
Miss Wilkie signed a lease, began on September 13th, 23, ended September 30th, 24. We did not force her out. She provided 2 30-day notices, and then she moved out the last day of her lease. We didn't necessarily want her to move. Usually lose a couple months of rent. The payments you have don't go away when somebody moves out. Miss Wilkie chose to move out. We did not force her out. We would have signed another lease. We would have extended the lease. Not a problem. When the eviction was filed, rent was still owed, even after considering the payment that was missing. If Miss Wilkie would have provided me with, as I said a couple times already, with the front and back of the money order, she would have had credit for it. It would have been done, simple, but she wouldn't do it until Billy Deschamps got involved. So payments were not made on time consistently. They were not made at all some months. That's very clear. Miss Wilkie chose to leave, and I don't feel responsible for any of that.
All right, the court makes its decision based on the proofs provided. I've had the opportunity to see exhibits 1 through 6. I've not only reviewed the exhibits, but I had the opportunity to see all exhibits and then hear testimony concerning those exhibits. That's plaintiff's exhibits 1 through 6, and then defense exhibit A through K were also admitted, and we took those one at a time. I don't know what happened at the landlord tenant at the initial, but it was dismissed in October. And now, Ms. Wilkie, you're indicating that Mr. Dowrick is responsible for the entire volume of what comes with being homeless. Okay, and you have to prove your case. You're the moving part. okay? You've sued Mr. Dowrick. And Mr. Dowrick doesn't have to provide any evidence, and he did, okay? There's no doubt I shouldn't say that. There's some question as to some of this is related to that eviction. You're saying you were wrongfully held under scrutiny for non-payment of rent, okay? And Mr. Dowrick's indicated that there's some question whether you paid rent every month, okay? And that's a dispute. And that ended up being with a filing of a dismissal in the case. So this lawsuit is $25,000 for the complaint. And I can read the complaint. I, Kier Wilkins, suing Todd Dowrick for wrongful eviction. Okay, there's the indication that you left. You weren't wrongfully evicted. You left of your own accord. Harassment and violations of Michigan law, Michigan summary preceding MCL 600.5701 and Michigan Consumer Protection Act 445.901. A landlord may only initiate summary proceeding for eviction when a tenant has failed to pay rent after a valid demand or otherwise violate a legal term of the lease. And you're indicating, your proofs have indicated that that's why he sued you, and that was improper. And Mr. Dowrick's indicated that you were not up to date on your rent. But he dismissed the case, and people dismiss cases for all kinds of reasons, okay? They may not want to go forward with the case, that a dismissal, they may just want the tenant out, okay? And then they get to re-rent, so that's my question. That's my problem here. My problem is directly tying Mr. Dowrick to the homelessness claim. And there's a lot of variables that come with homelessness. There's which hotel you pick. Why did you pick that hotel? Things of that nature. And you've provided me with receipts on all that, but I'm having trouble figuring out that this is all due from Mr. Dowrick. Okay.
Well, the evidence that I showed.
You're finished. I'm talking now, okay? All right. So I believe that you have not proven your case. The plaintiff has not proven their case in this case. This is a lawsuit brought by yourself. And so I'm filing after the exhibit of 6 plaintiff's exhibits, and then the A through K defense exhibits, I'm finding the plaintiff has not proven their case by preponderance of the evidence. I find, so the case is dismissed. Okay, the case would be dismissed. We will take care of the dismissal of the lawsuit. I will have Marcy type up a dismissal, and we'll take care of the dismissal of the lawsuit. But I do not believe you proved your case by preponderance of the evidence. There's some question, Ms. Wilkie, that you've proven your case at all, okay? We've adjourned this several times, and you've had a lot of time to bring a case together. And I don't know how a case is brought together that indicates that the landlord is responsible for the homelessness, okay? If the case is dismissed. I don't know that because there's a lot of variables that go into homelessness, all right? And that's the nature of it. And I need a direct causal link so that I can make a ruling based on these receipts are based on these items. And I have none of that. What I have are receipts, and then I have a dismissal of the case, and you chose to leave the case. And I'm not going to relitigate how this case was done because it was dismissed. But I find that the plaintiff has not met their burden of preponderance, and therefore I'm moving to dismiss this case. That's all for the record in docket 2501492. Thank you, everybody, for your appearance. You're all set. Thank you. And we'll take care of the order. So I'll sign the order. Verbally, I just speak. I verbally. It would be incumbent upon one of the litigants to follow up with an order that I signed, and we'll take care of the order to sign it. Okay, that dismisses the case. Either that, or then I would have to wait on you to admit the order, and you don't want to admit an order based on the fact that I dismissed the case. Mr. Dowrick could admit the order. We'll just take care of the order, and then it's done.
Thank you.
All right. I'm going to hand back the exhibits. So it's 1 through 6 are for the plaintiff. And I'll hand back these exhibits. So I'm returning at 1 through 6 the exhibits, and then A through K are handed back to the defense. as exhibits.
Will the form be mailed to us or we get it today?
You'll probably mailed it. Yeah, you'll probably mailed it because we probably won't do the dismissal till tomorrow. All right. All right, that's all for the record on 25-01-492. Thank you, everybody, for your appearance today.
Thank you.
At least, I'll get at least the notes put out.